So Katie, we're good to go on it. So members of the task force and public, I think we're live. We'll go ahead and get started on today's vulnerable adult and mental health task force meeting, the first one of the interim. And before we start comments, Katie, could we go ahead and take the roll?
Good morning, Mr. Chairman. This is roll call for the Mental Health and Vulnerable Adult Task Force for May 12th. Senator Barlow. Senator Nethercott.
Excused.
Representative Summers.
Here.
Representative Wanitzer.
Here.
Co-Chairman Baldwin.
Here.
Co-Chairman Larson.
Here.
For the Department of Health, Director Johansson.
Here.
For the Department of Family Services, Director Schmidt. Here. For the Department of Corrections, Deputy Director Babbitt. Here. For the Department of Education, Laurel Ballard. Here. For the Judicial Branch, Elisa Butler. Here. All present.
Thank you. So, Mr. Chairman, I'd like to take just a second for those that are here attending and those online to explain the intent of the task force as it's been assigned from Management Council, which was to look at mental health issues that we know are an increasing concern to the citizens across the state. They've allowed us to put together this task force. Chairman Baldwin and I looked at a number of options on how to approach the conversation around mental health and what we should be prepared to do in the next legislative session. And we elected rather to go out and try to investigate all of the options available in the world on mental health, to come back and focus on the work that's been done in Chairman Wanitzer's committee and Chairman Baldwin's Labor and Health committees, along with the work being done by the Department of Health and Department of Family Services and Corrections on the behavioral health redesign, and try to pick 3 or 4 topics that we think we can maybe low-hanging fruit. And so this interim, we're going to be focusing on our vulnerable adult population and policy, diversion, working to divert those individuals with mental health issues away from the court system and to get them help, working with a population of adolescents with high behavioral needs to develop a policy that to take care of them in a safety net type setting, and then the increasing presence of mental health issues in our K-12 system. And so today's effort, as we put together from each of those topics, ideas and information that would help this committee kind of get a foundation of where we're at, what the issues are, and then over the course of the interim, we'll go from today's meeting and expand and try to develop policies for the state, define what the state's role is, make any recommendations we feel is necessary back to standing committees for statutory changes and so forth. So, Mr. Chairman, with that explanation, any comments before we get started?
That was the best explanation I've heard all morning, Mr. Chairman. Thank you very much. And I apologize for my voice. So because I have a crappy voice this morning, Chairman Larson's going to do most of the talking. You don't want to hear me. Thank you. Very good.
Thank you, Chairman Baldwin. As we get started, we're going to start with our vulnerable adult topic today. We'll be taking committee, or we'll go ahead and take public comment on the respective issues at the end of each one of these issues. Kind of bearing in mind, trying to stay on schedule with this being a Friday and people trying to get home at a reasonable time and traveling distance. So I'm sure everybody's prepared and ready, and Mrs. Butler's smiling as though she has doubts in our capacity to do such a thing, but that would suggest that maybe she's sat in more than one of these meetings. So with that, we'd like to go ahead and start with our vulnerable adult. Director Schmidt, if you would kind of start walking us through what the Department of Family Services, who I believe has the charge for this, And also make note that we'll be referring back to a 2017 Governor's Vulnerable Adult Task Force. And a lot of the conversation will refer back to that in trying to move that forward to some degree. So the time is yours.
Thank you, Mr. Chairman, and everyone online in the committee room. The topic of vulnerable adults, as you know, in some of the materials, has really been starting to bubble up since 2016. And it was under Governor Meade that a conversation started to occur that was more preventative in nature. It was really thinking about what Wyoming's demographics look like and what are some of the issues that we were facing and could potentially face as the overall state starts to get a little bit older. I sure can. You guys are gonna. So I think the conversation today is a result of a few different issues that have come up. Certainly when I was recently appointed to this position, Representative Summers brought some issues to my attention in regard to vulnerable adults. And I think that was the beginning of the conversation for me in regard to the complications and really the differences in serving adults who are vulnerable as opposed to, in our world, abused and neglected children. And while some of the services we provide are similar, a lot of the attention and money goes to children and adolescents and families without a whole lot of time and effort really spent on vulnerable adults. So part of the conversation was a task force recommendation, which is in your packet and which is also online. That was the result of the conversation that the task force had with a list of recommendations about what to tackle. The turnover in administration from Governor Meade to Governor Gordon, and certainly everything else that's happened in a few years, this kind of didn't go by the wayside, but certainly we didn't pick up a lot of the recommendations in the task force and carry them forward. So I think the conversation today is to start where they left off. And the department has some responsibility in this conversation, but as you can tell from the task force, it really is much larger. There are legal issues, there are competency issues, there are funding issues, certainly there's organizational issues about what we can do for a vulnerable adult compared to what we do for vulnerable and abused children. And I think that's really the focus of what I hope today we can start to tackle. The information in your packet really talks about what the department's role in adult protective services is. And this is one of the places where the agency really has more of a secondary prevention role, meaning intervening before there's a complete crisis. And to be quite honest, when there's a crisis with an adult protective services case, we really don't have many options. I think it's important to remember that these are adults. And unlike children, where we all have minors, there's someone who's legally in control of the child. With adults, that's not the case. With adults, there's some mechanisms that we can use to bring in emergency services, or if there's something that's in regard to a serious mental health issue, then the courts can intervene through that type of action. But really, we don't have the ability to take an adult into protective custody and place them in a safe surrounding. So much of the work that the department does is really before, hopefully, those crises, and working with community partners, working with law enforcement, working with the senior living folks, whether that's nursing homes, assisted living, home care, to try to provide and organize services so that that adult can live safely at home. And that's where we try to focus our energy. But as the conversation, I think, will probably continue, you'll know that we only receive $80,000 a biennium to do that. We have 6 designated workers for adult protective services, and then the rest of the work is spread out throughout our agency. So I think that alone highlights some of the challenges we have ahead. I'm not advocating for a pile of money, but I do think it makes sense to have this conversation, knowing that all of the agencies really have limited funding and rely seriously on communities and really the generosity and the support of community-based organizations to help us with this. I also want to point out that while we talk a lot about vulnerability as an adult, an elderly person, we have vulnerabilities with a lot of our population. We have people, adults with developmental disabilities and intellectual disabilities. We have younger adults that maybe have some sort of organic brain disease or dementia, some kind of cognitive impairment. So while I think we have a tendency to think of maybe the stereotypical little old lady with gray hair in a wheelchair, we're really talking about across the board people who, for whatever reason, have a difficult time meeting their basic needs and taking care of themselves, which then also sets them up for vulnerability to exploitation, whether it be financial or otherwise. So, Mr. Chairman, I could certainly walk through the details of the handout about really what the agency can and can't do, or I can turn it over back to you.
Director, I think I'd like to let the members of the task force ask questions as they want, and I think that will lead more into what your role is. Members, questions? Representative Summers?
Mr. Chairman, and I apologize because I'm probably the guy that'll cause us to be the latest because it's just my typical history. But Director, thank you for the handout. It was a really good handout, and this has been a topic near and dear to my heart for quite a while. And when I look at in your report, I see that you kind of have a system established. You can designate in certain categories, and from that you can provide services if you have services. And when I looked in your gaps, it looked to me like you were using some ARPA dollars to cover what is potentially the gaps. One, I was wondering, how much, I guess, how much a year is the ARPA insertion? What really is needed out of that, and not just really nice to have? As I think I helped restore some of that money in appropriations that you do have when I was sitting there. And so I think you have the statutory authority for much of it. I think we're going to look at some bills. And I think you have the line item in the budget. The question is, what is the need? Realistically, what can we put towards it as a state? But I don't think we do have the money necessary to intervene in many of those circumstances to ensure somebody has the housing that's necessary, even if it's for a short period of time. So just curious on how much ARPA money, how much of it can we live without, and what do we really need?
Thank you, Mr. Chairman and Speaker Summers. The total amount of the ARPA money that I think we received was about $612,000. Is that correct? Okay, thank you. So there's the amount of money we've had. The way that we have spent the money has come from basically doing a needs assessment and finding out what communities needed or what the general population thought that they might need. And where the money is actually going is a lot to transportation and a lot to guardianships. So we've been able to spend direct service dollars on this population, things like house cleaning, which is a big deal when you have somebody who's maybe not as able to get around and then finds themselves in a situation where they're overwhelmed by their household. I mean, not necessarily a hoarder, but certainly living in an environment that's not safe. So we have spent money in those areas. I would say that, and this ties into the conversation later on with the legislation, is that guardianship really is a big deal. And I know it's a big deal as it applies to people with seriously and persistent mental illness at the state hospital. It also applies to people with developmental disabilities. But that guardianship, having somebody who can help and problem solve with that adult is important, and that's where we have found that we've spent most of the money.
Mr. Chairman, thank you. And so if you highlighted two of them, really, guardianship and transportation, that are probably key in this. And the guardianship, it seemed like, if I remember what I read, that was done through a third-party contract. One, on that third-party contract, is that available around the state? Is that only available in large cities? How did you provide services out through the state? And and once again, you don't have to do that now, but at some point during this task force, before we get to, when they draft a budget, certainly would like to understand what you think, we need for money, not necessarily the top dollar, but for example, if guardianship is the key to the success, perhaps transportation we can find within communities if we figure out how to do that. But so come up with a number. But on the guardianship, can you explain a little bit how that works and how that works around both rural and more urban areas of Wyoming?
Mr. Chairman, Speaker Summers, the guardianship largely flows through the Wyoming Guardianship Corporation, and they're a nonprofit entity. And I was looking and hoping to see maybe someone here, but they're a big part of the infrastructure around guardianship. So they employ people who then become the legal guardians, and they are statewide. They do have services throughout, but in terms of the specifics of exactly where they are, I don't have that level of detail, but certainly we could talk more about the role of the Wyoming Guardianship Corporation. I do know that in other states, they tackle guardianship in different ways. And in Wyoming, it's a little bit more complicated than maybe in other states. And I haven't done any deep research into how other states do it, but I do know comparatively that, for example, at a skilled nursing facility, accessing a guardianship through a skilled nursing facility is very difficult. And some states create opportunities for one stop. They can make one phone call, and then the system starts to take over from there. So it is a potential conversation, I think, in looking at how those services are delivered and should they be delivered differently. I don't mean to speak for Director Johansson, but I do know that that is very complicated on their end as well through Title 25, adults with serious and persistent mental illness. And I would assume the same for people with disabilities.
Thank you, Mr. Chairman. Just to add to Director Schmidt's point, and not getting into the specifics of, we also contract with Wyoming Guardianship Corporation and recently others to try to find guardians for adults that are either in our care or custody. Logistically and operationally, it's been very difficult the past several years for many of the populations we serve to find guardians, whether that's through Guardianship Corporation, who struggles to find folks, or when we reach out ourselves to community organizations, faith-based organizations, to try to have someone that can aid in decision-making there. I don't know what the answer is, but from the Department of Health side, and it's not just on State Hospital, Life Resource Center, DD, even at our nursing home in Basin, we have individuals that apply for service there and would qualify clinically to be served at the nursing home. But we have a little bit of a reservation given some of the diagnosis clinical information when there's no guardian in place, no family, and no power of attorney, where we would be put in a situation that potentially caring for that resident would require, even though we wouldn't want to, maybe require a Title 25 action or some sort of civil rights action so we can make decisions more regularly. So again, I don't know what the solution is, but I appreciate Department of Family Services, especially in this document, pointing out what a gap it is, because we struggle with it significantly in the department.
Online, we'll use microphones. My apologies, Mr. Chairman. Thank you, Mr. Chairman. So in the discussions we've had over many of the social services that we provide in the state, we're always talking about the safety net. And in this case, it seems like the gap is maybe that safety net piece. And so one of the things that I just pulled it up is we have a guardian ad litem office in the state of Wyoming, which has a legal component. Obviously, that's for children and it's in certain circumstances. But maybe there's a place in that, and I don't know what the funding structure for this corporation is. I don't know what, all that is, but maybe there's actually a state entity that we should be thinking about as having that safety net place on behalf of well, maybe it's the courts, but somewhere in there we have a safety net. This entity, and I'll let directors speak to this, is when we get to some of these more complex cases that really do require legal, attorney representation or legal things, I don't know that the corporation has that kind of expertise, or if they're more of the social issue type thing. So anyway, I just throw that out there as maybe this is a place we start trying to find those other things we can bring to the table.
So if I may follow up on that question, Senator Barlow, and I'll ask Elise here, but I believe guardian ad litems are available on adult situations, and if I'm mistaken on that, then maybe that's something we address. But if they currently do that in some situations, it might, to your point, have that agency in place that we could then consider further expanding those responsibilities in warranted situations. Am I wrong on that?
Mr. Chairman, guardian ad litems are used in some circumstances for vulnerable adults. I think, and again, this is off the top of my head, but the office of the guardian ad litem are required to act in that capacity for abuse and neglect cases for children, and then at their discretion for delinquency and CHINS cases. I don't know what the charge is for their office with regard to vulnerable adults, but when a GAL is appointed by the court to represent the interests of a child or a vulnerable adult, sometimes that comes through the office of the guardian ad litem. Often it is a private attorney who is appointed by the court. And I believe some of those funds are paid through the county, although I can't be absolutely sure with that. But yes, they can be appointed in those circumstances, but I don't think, and I hope I'm not speaking out of turn, but I don't think that's the charge of the office. Yeah, that's correct.
Response?
Mr. Chairman, correct. And going to the funding for the Office of the Guardian Ad Litem, they were once part of the Public Defender's Office, and I believe that's State General Fund. However, the Department of Family Services does pass through 4E money. That's federal funds for child welfare. So that also speaks to their charge that we're able to provide them some of those federal dollars for the services that are provided to children and families. And then the term guardian ad litem is not exclusive to the office of the guardian ad litem. The guardian ad litem is really a legal term and a person then who is assigned to represent best legal interests of an individual. So as Elisa pointed out, there can be private bar, not necessarily through the office of the guardian ad litem, but a court can appoint a guardian ad litem that comes through a private attorney. To back up Speaker or Senator Barlow's comment, I do think what we see with adults are a lot of legal complications through financial exploitation, or in the case of eviction or any of those kind of legal matters. And so a balance between that caseworker approach of that guardian ad litem through the Guardianship Corporation, who's really looking at best interests, also the ability to have some best legal interests in that mix, I think is important.
Dr. Schmidt, I want to go back to one of your first comments, if I could. I've got several questions that I'd like you to kind of help fill in. You said that for vulnerable adults, the Department of Family Service plays a secondary role. Explain that to me.
Mr. Chairman, kind of a secondary prevention role in that what we provide is a lot of case management. And that's in respect to what we can do with children, where we can take them into protective custody, but with adults, we can't do that. So our work is really limited to the most part what we can do for that person in their home, in the community, versus the furthest tertiary prevention, which is when we have them.
So with that, and that's kind of the reason I believe that ends up in your basket, is it's has some similarities to the way you handle chins and neglect in children. But in your opinion, have we clearly defined the state's role in how we handle vulnerable adult issues?
Mr. Chairman, when we talk about the state's role, I really think we also need to include in that the legal role. So we have the state in terms of the state agencies, but there's also some, I think, more conversation to be had around the definition and how far legally can the system get involved. And so the agency can respond at whatever level we need to, whether that's, at the very beginning where there's some identified issues, or where we really do come involved when we have a case, we're investigating it, we're really making those determinations. But I think the role of this group really is to tackle some of that idea about who exactly is vulnerable, because through that legal conversation, then it becomes more obvious what the agency's roles are in regard to that.
So along that line, as we hypothetically, if we were to close that gap and put into place the legal component of it, there's a segment of that population that you've identified that seems like we have some infrastructure already in place. Those that have mental impairments or things of that nature, we've kind of established a system for that. But what about the events for those outside that? If our legal issues are taken care of, we have a vulnerable adult that needs services, what capacity do you have then in providing the services, and what's the system in place, for example, for emergency services in Big Piney, Wyoming? And then does that trigger some secondary short-term services for stabilization, and then does that trigger some long-term services? And is that system in place? Do we have anything? Because it seems to me that once you get all of these legal things identified, it comes right back down to how do we take care of the person then?
And Mr. Chairman, I think the Department of Family Services does have an infrastructure in place to serve these adults. Through all of our county offices, through the legislation or the statute that tells us what to do, all of those policies and procedures are in place. And then we, just like we do with children and families, we rely heavily on our partnerships. So the Department of Health brings forward a tremendous amount of resources in terms of Medicaid, waiver dollars, et cetera. And then, of course, our partners through the nonprofit organizations and associations like AARP, who really pitch in. Certainly, the faith community is a big part of it, but that is all locally driven. And I think it's important that that be locally driven because the resources are at the local level. And I've found that statewide resources are a little bit more difficult to help communities meet their individual needs. I think the difference is the flexible funding and the money. And that is also similar to what we see later on in the conversation today around high needs children. When we have a situation where there's an adult that has real high needs, but they don't qualify for a nursing home level of care, but they can't quite stay at home either, that I think is where the big gap is, and that is where our agency really has very little capacity or ability to do much other than circle the wagons with our partners and do our best.
So then take that back to a hypothetical question in Big Piney. Lloyd Larson is found, he's needing help. Local resources have come in, the counties come in and say, this guy, he's living in squalor, he needs help. He's not been taking his medication because he can't afford to. What are you going to do with him?
Well, Mr. Chairman, we're going to start doing good casework. We're going to start looking for, are there any family members in the area? Are there any relatives?
You've got 2 hours.
then, Mr. Chairman, then I think we go to the courts, we go to the county attorney, and we ask for emergency services, and then legally we start to get involved, so we have a
But,
little more control.
and thank you, and that's kind of where I'm trying to get to. So walk us through that. So this is an emergency, we need to get it done, we're in Big Piney. Do you have the ability, and I'm just trying to provide the groundwork to identify any gaps or whatever, you refer to this flexible funding. So the county comes up and says, you know, we could put him in the nursing home in Evanston, they would take him. Do you have the ability to fund that?
Mr. Chairman, no, unless they're Medicaid eligible and unless they meet the requirements for the SNF, or they meet the medical necessity for a skilled nursing facility. Whether we could do private pay, possibly, that would depend on the nursing home.
But isn't that, Chairman Swanister, please.
Thanks, Mr. Chairman. Just to follow up, you said there were 6 personnel in DFS statewide. Are they, just maybe some information on what their role is? Are they investigative? Are they caregivers? Are they field offices? I'm just trying to understand the current framework.
Thank you, Mr. Chairman, Representative Swanitzer. So we have 6 designated caseworkers where their full caseload is adult protective services. Everywhere else, we still handle adult protective services cases, but it's usually in combination with abuse and neglect cases and delinquencies and children in need of supervision. And a lot of the work is the same. There's different legal requirements from adults compared to children, but it's working voluntarily first with a family, with a vulnerable adult. So we may get a report that someone thinks there's a vulnerable adult. They're Mr. Larson in Big Piney, who isn't taking care of himself, living in squalor, isn't taking his medications. Somehow somebody interacts with Mr. Larson and makes a call to us. We will then go out and look. Okay, so we're going to go out and assess the case. And most of the cases really are assessment. So we're going to say, wow, Mr. Larson, you're needing some extra things here. How can we help you? Who can we talk to? We could maybe bring in home health. We could maybe bring in public health nursing, or whoever it is in that community that maybe can support that person. And then we will then do our best to help them. Where it goes up a click, where we start to investigate, is if there's some allegations that somebody else is doing harm to that person or potentially exploiting that person. So then we start to investigate and say, okay, is this person being harmed because they're vulnerable? So it may be the situation of a caregiver, a family member, and typically the majority of it is family members, where maybe that family member who's designated as the caregiver isn't providing adequate and appropriate care. That then makes it a little bit of a different conversation. So when we investigate that, we are going to make a determination, is this person being abused or exploited financially or otherwise by a caregiver or someone who's in charge? If so, then we will say, the alleged perpetrator now becomes the perpetrator. We say to them, you have been found to have abused and neglected a vulnerable adult. We issue them the paperwork that says that, and then we say, you are now being placed on central registry because we don't want other people to engage with you because you will not take care of people appropriately. So that's when the case switches from just really about the vulnerable adult into a lot of the legal mechanisms as well that comes around financial exploitation, which was the conversation we had during the session, and other types of exploitation. So it's a little multidimensional than just self-neglect.
And I guess the reason for my line of questioning in getting to that is we want to be able, that I think the goal of this task force is that as we address this and we make the corrections we need to on the legal issues, that there needs to be a clear trail on the options those people who are faced with making the decisions on behalf of the state for the citizens of the state, that if we can do A, B, C, D, and these resources, these are the boxes you check, and if this is the situation, we've got the resources to do one of the things necessary to put this person into safety. And I agree that we do have a system in place, but I think there's some anomalies in there that I'm hoping that as we move forward that we try to address, and that comes back to Representative Summers' conversation on funding. I don't know where to put the funding and what that is, and so we need to identify the plan to say, we really need to make sure that, like we did on these high behavioral needs kids, to have some funds available that we can leverage other funding or take care of this emergency placement for these adults. And so just trying to paint that picture in that situation. Any other questions? Director Johansson?
Thank you, Mr. Chairman. Just a technical question for Director Schmidt or maybe her fine staff that are here. On page 4 of the document, on looking at APS data, it looks like there's about 1,000 less screened in or accepted reports than the number of reports filed. What qualifies as an accepted report? How does that number get ratcheted down?
Mr. Chairman, Director Johansson, I'm going to look to my team and I'm going to talk and you can shake your head yes or no. My understanding is that we have rules around what the definition of a vulnerable adult is. And so when we get a call and someone thinks that someone's a vulnerable adult, we're going to look at the statute, look at our rules, and then make the determination based on that. And this is sticky. And the reason why it's sticky is because just like with children, we want people to live a certain life. And with adults, they get to pick that life. And while it doesn't necessarily conform with what we would think is appropriate and adequate, in their mind it is. So the conversations around adults gets very different because adults have rights that in the case of children don't necessarily have. So the screened in, screened out is really going to be a conversation with the adult. It's going to be talking to the reporter, looking into ancillary conversations, and then we make a decision and we may screen it out. An example of that is when you have a neighbor, who calls it in and there's trash all over the house, and that neighbor says, this is a vulnerable adult, somebody needs to come over and do something. We go over, we visit. They may be living in squalor, but they're not necessarily vulnerable just by that description. So that's why you see a large number screened out. If you saw our Child Protective Services data, you would see similar type of data.
Is it fair, Director Schmidt, though, to say that those reports are those are just the ones that you know about? And so as we look at some of the proposed legislative changes, if there's a call comes into you, you have to make that report to law enforcement. But I think in most rural communities, the people are going to call law enforcement, and they're not required to contact you and identify. They'll handle it the best they can. And so there may be situations out there that need to be screened. You're just not aware of them because law enforcement doesn't contact you.
Yes, Mr. Chairman, that's correct. And where that gets a little bit more concerning is that we oftentimes have more information than maybe what law enforcement has. So while law enforcement can go out and investigate and look, they may not have the collateral information that we have. And so if they wait to only inform us after they've made a decision of vulnerability, there may have been actual vulnerability, but what law enforcement saw, we have more history, doesn't really get to that. And Mr. Chairman, I think where that's especially important is where it comes into financial exploitation and exploitation, abuse, and neglect, less so than a vulnerable adult because of self-neglect.
Thank you, Mr. Chairman. So this coordination or communication between the Department of Family Services and law enforcement, which is of course many agencies across the state, it seems like under current statute, there's a duty report obligation, and then there are consequences for not doing so, but there's no duty to coordinate. There's no duty to report or to work within each other. So you spoke about a registry a moment ago, and that's a registry actually for people who you do not want to be caretakers or do not. What about a registry for the vulnerable individuals themselves? Is there that, and is there a way, is that available? And if not, is that a way we could actually have a better coordination between the different entities who may be the initial intake or maybe the initial officer or caseworker that sees this, and then they can follow through. So maybe there's 2 or 3 questions there. Thank you, Mr. Chairman.
Mr. Chairman, Senator Barlow, so the central registry exists, one, because of the statutes that are listed for adult protective services and also for abused and neglected children. And those types of cases are civil, they're not necessarily criminal. And therefore, that information is not public information. So if I, as a caregiver, have abused and neglected my mother, but it didn't rise legally, or for whatever reason, law enforcement did not criminally charge, but yet under our rules, our statutes, we determined that I had abused or neglected an adult, the central registry captures that information as a protection to the general public because it's not available through the courts. So it's a very limited database of people who have found by the department under our laws and rules to have abused and neglected a child or a vulnerable adult. That registry is then available for the general public even to be able to come to us and say, does this person exist on the central registry? So if I then wanted to get a job as a home health caregiver, then that agency could request through the Department of Family Services a central registry check that would say, has this person abused and neglected an adult or a child? And then we would say, yes. So that is real specific to the perpetrator. Then you asked about the adult themselves. And yes, we keep those kinds of records within our agency in our case management system. That information, though, is highly confidential. So if we wanted to have a conversation about access to that system for these purposes, I think we would have to have a different conversation about what are the legalities around that and giving us permission. But as it stands right now, no, that would not be available to the general public.
Mr. Chairman. So, Mr. Chairman, I guess in my view, that last component is important, at least to be thinking on, because the way that 103, which is the duty to report, it is any person or agency, and then it's the information immediately report immediately to law enforcement or the department. Well, if the department and law enforcement actually aren't talking together, we have no coordination, then we need to figure out either a informal mechanism, and I'm not interested in the public knowing this information. I'm interested in the entities and the agencies who are interacting and trying to do this protective work, having the ability to understand the greatest amount of information and then coordinate the most services through DFS. So anyway, I just think that I'll study this some more, but this gets down to definitions and truly how you connect those right people so you get full protection, or the best protection you can at a timely manner. So thank you, Mr. Chairman.
Thank you, Mr. Chairman. Elisa Butler, I'm so used to testifying. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. So I think we come at this, as with most things, from a very different perspective, and that is Unfortunately, the courts are not focused on prevention. We come into play when something has happened, and so the case comes to our judges to decide. That happens in a couple of different contexts in this world. One is emergency services, as Director Schmidt just mentioned. The other is when somebody petitions for a guardianship or conservatorship over a vulnerable adult or an adult who is unable to make decisions for themselves in those contexts. And so I think from the task force report, there are a couple things that I think were identified with regard to the courts, and Director Schmidt already talked about one of these, but that is the availability of guardians for vulnerable adults across the state is limited. My understanding in talking with the judges is that the Wyoming Guardianship Corporation is wonderful, but we don't have enough guardians in that regard to act in that capacity for those vulnerable adults. The need is too great for the availability. So that is one of the items that was recognized in the task force, and I think one of the items that I've heard from the judges across the state. And then the other piece of that with guardianships and conservatorships is ensuring that they are qualified to act in that capacity. So much of the time, and I think this again was in the task force report, it is a family member who acts as a guardianship or a guardian or conservator, and often that results in some kind of malfeasance, unfortunately. And so ensuring that the person who is appointed as a guardian or conservator is qualified is something that was identified. Truth be told, I'm not sure how the courts play into that. I think it's incredibly difficult. There is no, real mechanism within statute to require certain qualifications for a conservator or guardian. And so, in these circumstances, the judges are faced with making a decision about whether a person should act in that capacity without potentially knowing some of the underlying information about the person who is requesting that. So those are just some of the things from the court's perspective that we see as potential problems. Unfortunately, I'm not coming to you with too many answers, but I think the task force report really kind of lays that out pretty clearly in terms of where the gaps lie, and I think those gaps still are there. There are a couple of things from the task force report that the legislature has moved forward with. The Uniform Power of Attorney Act was implemented, I believe, in 2017. And so that is 18, my apologies. So that is in place now. Also, and Director Schmidt talked about this during this last session, there was legislation passed on financial exploitation of vulnerable adults, which I think is a step in the right direction. So I would be happy to answer any questions. That's the perspective from the judiciary.
Questions?
Mr. Chairman, thank you. And maybe I'll just save it, I think, till we hit the bill. But I think as we look at what is the definition of a vulnerable adult, I am very interested in what the court thinks. So I'll just wait till that time. But I think that's an important place to get your feedback.
Any other questions for Lisa? I might just go back, if I may, Senator Barlow, on your comment in 352103. And if you would look at that draft bill, do you think we've covered that, or do we need to add a little more? So, that's just a question that maybe as Anna goes through that we can maybe consider, because I think if I'm hearing you right, we may need to add a little bit more. Thank you. Green light. Anna will have you come and kind of share with us those bill drafts we have. When I looked at the 2017 Governor's Task Force on Vulnerable Adults, there were several recommendations that they made. As Elise pointed out, several of those we've addressed. There was one, particularly the one on vulnerable adults, that came forth and failed, went through the Senate, failed in the House. So I just asked her, to look at those again. I think Chairman Zwanitzer, I think you was a co-sponsor on that bill, if memory serves me correct. But I think what I've suggested is maybe we get those bill drafts ready and consider them as we move forward, and then at least have a foundation for something to kind of consider. So if you'd walk us through each of these, and at the end of each one, let's just take some comments or questions in case we need to tweak them a little. Thank you. Yes, Representative Summers.
Mr. Chairman, thank you. And you know, I don't know if it'd be beneficial, I guess we've all read it, but I think for the audience, I do think that memo that they put out that is the basis for the bill drafts, I don't know if we could get a quick rundown of that.
Absolutely.
Of that memo. I think that's important.
And I think that's the intent of what she's. Go ahead.
Mr. Chairman, Donna Shippen actually
Oh, that's right.
produced that memo, if you want her to go through it first.
Donna, we, would you indulge us?
Hi, Mr. Chairman. It's,
So, members, that's the one on April 23rd. Legislative actions responsible for 2017, right?
that's correct.
Okay.
That's a fact sheet that should be in your meeting materials. Just to go over this quickly, it looked like the 2017 Governor's Task Force made 6 legislative recommendations, and they're summarized in this fact sheet. And really only one of those 6 recommendations has been enacted since that task force. So the first recommendation is the one that was enacted. It was that Wyoming should adopt the Uniform Power of Attorney Act, and that was passed in 2017, went into effect January 1st, 2018. The second recommendation was to mandate cross-reporting between DFS and law enforcement, but no action has been taken on that to date. The third recommendation is on page 4 of the fact sheet, and that was to strengthen adult protective services by amending the definition, the statutory definition of vulnerable adult. There was a draft bill that was introduced into the 2018 legislative session, but it failed.
Mr. Chairman, I just had a question on that.
Representative Summers.
Mr. Chairman, thank you. Was that a bill out of judiciary, or was that an individual bill, or?
It's an individual bill.
I
was an
believe it was an
individual
individual bill.
Thank you.
The fourth recommendation is on page 5 of the fact sheet, and that was to adopt a civil cause of action for vulnerable adult abuse, and no action has been taken to date. The fifth recommendation was to extend time for emergency protective services. The recommendation of the task force was to extend the current time that's required in statute, so which is 72 hours. A person can be held for emergency protective services, and the recommendation was to extend that to 14 days. There has been action taken on this recommendation, but it did not extend the period to 14 days. Instead, the 72-hour order was amended to exclude weekends and holidays from the calculation of that 72 hours. But the period is still 72 hours. But the amendment that was put in place in 2017 also allows the extension of the 72-hour order up to an additional 30 days. I don't know if that makes sense.
It does.
Okay. And then the sixth recommendation, again, which is on page 6 of the fact sheet, was to improve the process and resources for emergency guardianship, and there's been no action taken on that recommendation to date.
Questions? Okay, Anna?
Thank you, Mr. Chairman. This first bill draft would change the definition of vulnerable adult. And it reads that any person who lacks the capacity to consent or is unable to provide for their own care or protect themselves from abuse, neglect, exploitation, intimidation, abandonment, or self-neglect due to a physical, emotional, developmental, or mental disability, the effects of illness, injury, or accident, or residency in a nursing care or similar facility would be considered a vulnerable adult. And I would take any questions on that one.
And I think if you could just give us a highlight, I think that the courts provided us some cases where that was
Right.
problematic. If you could just help us understand why this is important in some relevant cases.
Of course. There were 3 cases that came up recently where the definition of vulnerable adult came up because the definition as it stands now is a little ambiguous. And so in Larkin's versus, well, in the Larkin's case, it was argued that the victim in the case was not a vulnerable adult because he could do most tasks of daily living, but it turns out that he had spina bifida, he was in a wheelchair, he needed help cleaning himself and needed help getting to doctor's appointments. And the court in that case held that he was a vulnerable adult because of his physical disabilities and his inability to carry out some tasks of daily living. In the Blevins case, it was argued that the victim wasn't a vulnerable adult because he was able to generally lead an independent life. However, he needed assistance with physical tasks, he had some cognitive issues, he also needed help with his financial affairs, and for that reason, the court found that he was a vulnerable adult. And then in Brown, the victim in the case had Down syndrome. The defendant argued that he was too intoxicated to be able to tell that the person was a vulnerable adult, but the court held that the defendant should have known that the victim was a vulnerable adult because of factors such as her physical features and mannerisms. And I would take any questions on those.
Representative Summers?
So, Mr. Chairman, as I look at the report from 2017, and I'm sure that there was the discussion between you and the chairman probably that resulted in this, but I see different, I guess, verbiage in the report from the task force versus the language in the bill. And so I'm wondering how is this the language that was in the bill that was brought the last time that failed, or where does this particular language that we're looking at here come from?
That came up through the review process when we were putting the bill together. That was more peer review and what have you as we were putting the bill together and as it went through review.
And then my question, Mr. Chairman, would be as we get into this is, I'd like to hear from the experts here, their viewpoint of this definition and the effect of that definition.
Well, absolutely, and that's why I wanted to get these out early, because this isn't something that we're going to determine today, but it kind of gives you a flavor and certainly have the ability to change as we identify that. Senator Barlow.
Thank you, Mr. Chairman. I think one of the things to keep in mind is with the version, there are both with bills that fail, there are both opposite engrossed versions and introduced versions. And some of what we're seeing is, I think, some difference in that. The version that died in the House was an engrossed version. And I think what we're looking at is actually the introduced version of the bill. So there were changes made, and we should keep that in mind as we proceed to Speaker Summers' point as, can we make it match better? And I don't know which one is right. I just know that there are 2 different versions, and we're looking at one, and there's a second one that actually went through one of the bodies. Thank you.
So we might just ask, Anna, if you would, when we get done, send us the committee out that engrossed copy, and we can make that comparison, just have it in our file.
Yes, Mr. Chairman, I can do that.
Director Johansson.
Thank you, Mr. Chairman. Maybe for Director Schmidt or LSO, and a naive question just for my edification, regardless of what the definition says here in Title 35, the idea is that that definition of a vulnerable adult would, in theory, kick off the process that you described earlier with how the state or an agency gets involved at any point in that process. before we debate, if that's a good system, if there's more that's needed, if it's expansive, that's essentially what this Title 35 mechanism does. Is that right?
Mr. Chairman, Director Johansson, yes. I mean, that doesn't limit our ability to work voluntarily with that case, but it certainly puts that legal framework into place for whatever action that occurs after that, whether it's the emergency services that kicks in through the court, whether that's a determination that there was a perpetrator and then therefore that name goes on central registry. But yes, that sets the legal definition for us to maneuver. And Mr. Chairman, if I may, a couple points about this piece of legislation. I can't see Tom Laycock directly, but this was an interesting bill. When this came out in 2018, it was not too long after the Department of Health took over operations of the Department of Family Services. So the Department of Family, so I was new to this discussion when this bill was being discussed in 2018 during the, on both sides. Certainly the AARP was a really good advocate and was a lot more involved with the conversations around the changes in legislation or the changes in the bill draft from one house into the other. But it created a lot of debate. And so I think it is wise for this group to really be sure of what it is that this group is comfortable with, because it does really start to get into some very difficult spaces about the right of an individual and the autonomy of an individual. And then, Mr. Chairman, to your question a while ago, then what is the role of the state? And I see that we have some advocates here that I think can speak to some of the various aspects of what a change in definition might be as it applies to, for example, Alzheimer's, as it applies to temporary conditions as a result of perhaps a stroke. So there, I think really being deliberate around this particular legislation would be prudent.
Mr. Chairman, on that note, I think it might be helpful for either someone on our staff to actually look at some other states, and maybe there's some, I hate to your model language, but there's some other language out there that we can take a look at, because what we're talking about now, it seems to me we're talking about mental health as a qualifier, Title 25, and then you start talking about competency, and then you have lack or unwillingness to consent, which is, I think, what the director talks about. Then we are starting to get into a real tricky spot. So I think if there's some other things out there that may give us some at least suggestions to consider, that might be helpful as well. Thank you, Mr. Chairman.
Thank you. Okay. Any other questions? Okay. Anna, let's move on to the next one, please. We're going to try and pick it up just a little bit.
Thank you. Thank you, Mr. Chairman. The second bill draft you have in front of you is the civil cause of action for vulnerable adults. This bill draft would allow a vulnerable adult to have a cause of action against anyone who exploited or financially exploited the vulnerable adult. The vulnerable adult would be able to recover damages, actual damages, and punitive damages if the court finds the person acted with malicious intent. And the action can be brought by the vulnerable adult, his guardian or conservator, or by a personal representative of the estate or of a deceased vulnerable adult.
And Anna, you might just share with them, we've had some feedback on this one, I believe, and just share that with us and know that we're kind of, same thing, we're kind of massaging that and looking at the right language and how that, and where it works.
Well, right now, the bill draft has financial exploitation and exploitation because there are two different definitions in statute. One is the newly enacted financial exploitation definition that was just enacted in the last legislative session. And then there's exploitation in Title 35. So it might be beneficial to just use a vulnerable adult who has been exploited pursuant to 35-2102, just to get rid of some of that ambiguity.
So things we can be kind of looking at, and if you would maybe share that little note that you had on that explanation with the task force, and we can kind of be playing with that in our own mind, okay?
Right.
Next one.
Okay. The next bill regards cross-reporting between law enforcement and DFS. This bill draft would require law enforcement to notify DFS if they receive a report that a vulnerable adult is being abused, neglected, exploited, intimidated, or abandoned. Currently, law enforcement only notifies DFS if they determine that any of these things have actually occurred. And this would just require that they notify DFS if they receive a report.
Mr. Chairman,
Okay, Director Johansson.
what's a report in this context? Is it an actual physical report, phone call?
Director Schmidt.
Mr. Chairman, Director, all of the above. Yes, it could be a call to, it could be any way that, a notification is basically maybe what would be a term.
Is there a requirement to note? I mean, so if I'm law enforcement and I call you, then is there a requirement to record that report, that it's been logged in or something to know that? Or can I just say, no, I told her, I seen her at the supermarket and I told her and I reported that. So how does that work?
Mr. Chairman, for the department, that we would note that, we would enter that. In terms of law enforcement, I'm not sure how they would document that if they have a process.
And this is the one Senator Barlow I was referring to, that you might see if that covers what you were looking at. So any other questions? Representative Zonesser,
Thanks,
please.
Mr. Chairman. I guess my concern or my question is, are we putting the law enforcement officer is determining right now if that adult is in fact vulnerable and has to make a decision on the spot then when it's now, I guess I have concerns with you're basically making law enforcement, the person says, hey, I'm not a vulnerable adult, and the law enforcement officer has to say, well, I think you are, and I'm going to turn over that report. Is that individual notified that that report is being turned over, I guess is my question, and they're being claimed to be a vulnerable adult? Is that part of the report that gets turned over to DFS? Do they get to know about that?
Mr. Chairman, Representative Swanitzer, I think in a community sense, if a law enforcement has made the determination that it's that this person's a vulnerable adult and thus is required to report to the department, then we would open a case and go out and investigate as well. So because they can make that determination, but we're going to have to support it against our rules and regulations. Because if it involves someone else and we substantiate, we need to make sure that we've done our due diligence as well. In practice, for the most part, we work very well with law enforcement. I mean, so this is one of those very community-based relationship issues. However, if law enforcement under the current statute says we have no obligation to tell you anything DFS until we make a determination that that person is vulnerable, that's the tricky spot, because again, we may have had other reports, which we also inform law enforcement, but it's just the continuous back and forth. Where we see it play out, why timing is essential, and I think this was a lot of discussion during the session, was around financial exploitation. And so if law enforcement is looking into it, but they don't have all the information, then there's potentially that time where then the financial exploitation is happening. And by the time the department gets involved, and if we had previous reports, it may be too late. I do think the legislation has helped a lot with that, but still there's other situations where having that information as early as possible will help us and help the system do better overall.
So Director Schmidt, if whose evaluation is superior? If well, in fairness, statutorily, if law enforcement comes in and says it's a vulnerable adult, reports it to you, you come back in and say, no, we don't think so. So which one prevails?
Mr. Chairman, so if law enforcement makes the determination based on what they think meets the definition and they come to us and we say no, then we're going to have that discussion. I don't know if necessarily there's a trumping, but at the end of the day, we decide what meets our rules and what doesn't. So in purposes of that term, vulnerable adult, especially if it involves someone else, we would decide whether or not that incident meets the statutory and rules standard to then be registered in central registry. We would make that determination. And Mr. Chairman, I would think that law enforcement really has some other opportunities to argue with us through the courts. They could go to their county attorney, and then the county attorney could step in, and then the courts would overrule us.
Just real quick, not to belabor this, but the operative change here, as I see it in this paragraph, is law enforcement doesn't make a determination anymore. They receive a report of potential exploitation, abuse, neglect, and they forward it on to DFS. That's the change.
Mr. Chairman, Director, not necessarily. If there's some criminal issues happening, the law enforcement will continue to investigate. This is just notification.
Right, gotcha.
So this change does not mean that law enforcement hands the case over to us. What this means is that law enforcement notifies us that they are investigating a case, that they are looking into it. With this kind of civil statute and the same thing with child abuse and neglect, there's two different standards that we're looking at. We're looking at criminal standards in terms of did that person commit a crime versus under, for example, Title 14 juvenile court, which is a lower standard, did somebody abuse and neglect? So oftentimes in those situations, cases will run concurrently. So law enforcement will be investigating, working with their county attorney on the criminal side. We will be investigating to see if the incident met our standard for abuse and neglect.
So then I guess my question is, are you required as a department now under statute to investigate all reports that you get? So I'm upset at my neighbor. I say, hey, he's a vulnerable adult. I call law enforcement, probably nothing going on, but now law enforcement has to tell the department. Now the department's out there as well. Is it required as soon as you get a report that you have to go investigate? You feel like you should, otherwise something's going on, you don't investigate, you're liable. So is this a lot more bureaucracy for you with this change?
Director Schmidt.
Mr. Chairman, Representative Zwanitzer, we're going to talk to the person who's reporting. So if it's law enforcement or whoever's reporting, we're going to get their story and we're going to be checking it against our rules, our standards, and saying, does this really rise to the level? Hence the reason why you see screened out reports. There are going to be key things that are going to make us look a little bit deeper. For example, have there been numerous reports on this particular individual? Have they all been from, is there medical reports that have come in? So we're going to cooperate in different ways. It may require a visit to the person in question, or it may be conversations with others just to see if we need to go further. And honestly, the system gets used to beat each other up as well. I mean, there are times where the agency and law enforcement will get reports because people are mad at each other. And so we have to be real careful in that situation as well to make sure we're not getting unnecessarily involved because there's a neighborhood spat going on. So we're very careful to ask all the questions.
Further questions? Okay, Anna, thank you. Did we get through them all, or do you still have one? One more. Okay, thank you. Oh, emergency services. Representative Summers, please.
So, Mr. Chairman, maybe somebody can tell me how this ties in with Title 25 and the 72 hours there, if this is the same thing. And then, you know, on the 14 days, emergency protective services, who pays for the 14 days or who pays for the 72 hours? I know that on the Title 25, but I'm not sure what this is.
You want to take, Director Schmidt, is that you or is that Elise?
Mr. Chairman, Speaker Summers, I'll take the last question first and then hand it over to the director to talk about the Title 25.
Okay, thank you.
Speaker Summers, the emergency services just say to the vulnerable adult, you're vulnerable and the department will work with you, you shall work with people. It's that leverage to say the court is stepping in. But again, we can't take protective custody. So when it comes to whatever that vulnerable adult needs, we go back to our budget, we look, we try to rely on community resources to get those services in place, but we do not have necessarily the money to provide the shelter that they may need. We may coordinate with a shelter in the area to provide housing, but we don't have the financial, we do not have the budget. I mean, we could pay for it, but we've not designated in our budget that extensive amount of money to pay for the sole care of a vulnerable adult.
Well, and Director Schmidt, also the idea here on extending the services is that in an emergency situation, the 72 hours just is insufficient. Doesn't mean that it has to go to 14 days, but can go up to 14 days. And then with the language that we put in could be extended then for another 30 days, I believe, if so warranted. But I think the idea here was that the services provided 72 hours just wasn't enough, and that they needed the extra time to make sure that the person was stable and was in safe care. Am I seeing that accurately?
Yes, Mr. Chairman, and I think Elisa, that it's also just ties up the courts unnecessarily to keep coming back when what we know is that 3 days isn't sufficient.
Chairman, thank you. So Elise, kind of tell me, and maybe you don't know, but how many of these do you see? I mean, in broad terms, if you have any idea, like 10, like 100. So we have some idea of if we extend this 14 days, what is that going to mean? And what's that impact going to be if we decide to actually fund it?
Mr. Chairman, Speaker Summers, I don't have any idea, but we can look into that and get some numbers for you. The 72 hours really, so when there's an emergency situation for a vulnerable adult, it comes back to consent, and that whole issue of these are adults rather than children. And so 72 hours really is that time frame is meant to address the emergency situation that the vulnerable adult is in, and thereafter there has to be some kind of process for consent to be given after the emergency is addressed, right? Either by the adult themselves or a guardian or a GAL or somebody else to come in and say, yes, please provide additional services for this person. But when the court steps in and says, DFS, you will provide services for this person, it is because there's an emergency situation that needs to be addressed in that moment. And so they have 72 hours to address that issue. And my understanding is oftentimes that's just not enough time to address the emergency. And so the extension of 14 days would give DFS more time to address the situation, again, without having to come back to the court and say, please make a finding that we need to extend this to 30 days. The statute does currently allow that extension, but it gives them a little more time to address the emergency and potentially not have to come back to court and ask for that additional time.
So Director Johansson, it appears to me that if we were talking about a person who was at risk of injury to themselves or somebody else at Title 25, that moves them over into a different lane on the highway in this conversation. But would you clarify that and make sure I'm understanding it correctly?
Mr. Chairman, yes. So there's some overlap to Speaker Summers' point with this population, especially when the court's determining, are they committing self-neglect or inability to care for themselves? Those terms appear in Title 25 and here in Title 35 in some ways. The real difference with Title 25 is that happening either danger to self or others or inability to care for oneself as a result of a mental illness. And if that's the case, then I think a court would determine, okay, we need to look at Title 25 action here for emergency detention in more of an involuntary hospitalization type of a role, as opposed to, here, this triggers the vulnerable adult definition, which has some of those elements, but is really, the person lacks capacity to make decisions and is being abused, exploited, those different options where psychiatric hospitalization is likely not necessary.
Thank you, Mr. Chairman. So in Title 25, there are limits. There are 6-month extensions. Is it the practice that there's only a 30-day and then it has to go back to the court completely and start all over in this particular case? Because this limits it to 30 days or an additional 30-day period for an order, extension of an order. So is there multiple extensions? I guess my question is there multiple extensions available? Thank you.
I would suggest that it's absent of that language, and is there any disagreement there? And is that something that we would want to say, that maybe change that language to say that can be as appropriate up for 30-day extensions, right? So it could happen more than once. Doesn't have to, but I think it leaves that to where we don't have to do that. So,
Mr. Chairman, I think we would have to change the language a little bit to allow for that.
okay.
Definitely.
Okay. Any other questions on this one? How about any sidebar discussions that we need to have on this conversation? Okay. Anna, did we get everything taken care of?
Mr. Chairman, we did.
Thank you, and thank you for getting these ready for us.
Oh, you're welcome.
Good job. Director Johansson?
Can I ask a logistical question? So we look at these bills, discuss them as a task force here. What's the mechanism in this interim for legislation? Is it recommendation to a standing? Is it this task force? I can't recall the establishing authority.
We'll make, yeah,
Just let Senator Barlow do it.
yeah. Well, yes, that's right. No, we'll recommend it to a standing committee. And we really have, and that's kind of the makeup of this task force. So we've got labor and health, Senator Nethercott and I are on appropriations. We've got, I've been talking to the Judiciary Committee as well. So and Education Committee as well. Okay. Katie, I think we're, barring any other questions or comments from the task force, I think we're ready to, on this section, to go into public comment. So we'd like to invite, I think we may have one online, Katie, if that individual, I think that's,
Mr. Chairman,
yes.
will you please ask them to raise their hands if they'd like to address this topic as an attendee? I have Cassie
So
Crum-
any of the online attendees, if anyone would like to make a public comment, please raise your hand. And do we have anybody here come on up and identify yourself, and we'll let those online kind of get organized a little bit, and we'll go to them second or third, okay?
How's that? Is that better? Okay.
That is
Thank you,
better.
Mr. Chairman. My name is Max Esdale. I'm just here as a private citizen. I
Say
heard
that, you're with who?
I'm a private citizen.
Okay.
I'm not here with any affiliation,
Okay.
just because mental health is so important. I heard several of you speak at the summit last month in Casper. Thank you for your dedication to addressing these serious issues. I would like to suggest that the task force consider the benefits of breakthrough therapeutic treatments, legislation similar to what we've seen introduced in other states such as Utah. There are treatments that are available today for several of the illnesses our vulnerable adults suffer from that will likely take years to get FDA approval, such as debilitating depression, PTSD, and addiction, as well as end-of-life care. I have brought some references for recent and ongoing research for anyone who's interested, and at the suggestion of Senator Baldwin, I will follow up with example legislation from other states. So this is the scientific basis, and I will follow up with the legal basis. Thank you.
And then if you could just leave a copy, and we'll ask LSO to distribute a copy to us.
Thank you. Sorry, who should I leave that with?
Any of those three hands.
Thank you very much. I appreciate your time.
Any questions, committee? Thank you. Thanks for being here.
Thank you.
Anybody else? AARP? Tom, welcome.
Well, thank you very much, Chairman Larson, members of the committee. I'm Tom Laycock. A little closer? A little better? All right. Chairman Larson, thank you for the welcome. Chairman Baldwin, I hope you're feeling better soon. Members of the committee, I'm Tom Laycock with AARP. We're a membership organization for people age 50 and over, and we have more than 80,000 members in the state of Wyoming. So first and foremost, I want to thank Donna Shipman for her work on that memo. I read it a couple weeks ago, and for someone who just came on board just before that 2018 session at AARP, that did a great job of kind of bringing me up to speed, so I very much appreciate the work that you put into it. Secondly, we want to thank those who took part in the 2017 task force. Their recommendations were reasonable and very actionable. AARP did work hard to help pass the Uniform Power of Attorney Act and supported the bill to change the statutory definition of vulnerable adult in 2018. I also want to thank the committee for picking up the ball and running with the question of what is the role of state government in determining who is vulnerable and how we work with those that fall into that category of vulnerable. AARP believes there should be laws laying out who is a vulnerable adult. We believe these laws should be applied to the community and in long-term care settings. Such laws should balance the individual's autonomy and self-determination with the state's obligation to protect those who are unable to protect themselves. We believe there's tremendous merit to bringing the draft bills that you've discussed today. Last year, Senate passed Senate File 24, the financial exploitation of vulnerable adults bill. And at times that debate really fell into a question of what makes a vulnerable adult. So I think there's quite a bit of appetite out there to have that particular conversation. Exploitation of vulnerable adults is tough to prove sometimes, difficult to litigate and prosecute, but I don't think that means we walk away from our responsibility as a state. In fact, along those lines, as we talk about, that question of what is a vulnerable adult, it does sort of become incumbent upon us to explain what these changes would mean in terms of very simple and actionable steps. I remember in 2018, that was the first bill that I actually lobbied on behalf of AARP. There were a lot of questions and concerns about do these changes mean that the police or APS can come in and drag grandma kicking and screaming out of her home, and I don't believe that was the case or is something that DFS can do. So I think having those conversations early is a good idea. One thing I did want to point out as we talk about vulnerable adult is the fact of the matter is we are aging quickly as a state, and that requires us to get our house in order when it comes to how we take care of our state's aging population, some of whom will fall under the definition of vulnerable adults. Consider in July of 2022, the State Economic Analysis Division reports Wyoming's percentage of those aged 65 and over will rise to over 20% of the state's entire population by 2030. The state's oldest county is Hot Springs with a median age of 48, and 28% of its population is age 65 and over. Johnson, Platte, and Park County round out the list of the state's 4 oldest. One thing I did want to point out is APS did a really nice job of putting together sort of who we are and what we do and how we can do it. Actually, on page 3 of today's meeting materials, DFS discussed their feedback from numerous sources to detect gaps in services. The paper reads on page 3, quote, "The most significant area of need identified are transportation for vulnerable adults and timely guardianship services," unquote. Last year, APS came forward to some of its friends in public health with the survey data around transportation. We have put together a small coalition to look at ways to get older adults help with rides from everything from medical appointments to grocery store trips. We're continuing to meet. Among the groups that are working on that issue, Jen Davis at the Governor's Office, APS, Department of Health's Aging Division, WYDOT, Mountain Pacific Quality Health, and AARP. At AARP, we do have advisors with backgrounds in rural transportation networks, and that includes some that have worked with other municipalities on everything from rideshare programs to just the basic questions on software around how to help with scheduling. Our next meeting is May 17th. Hopefully our coalition can bring some solutions to this group and make it a little easier for those who are in danger of becoming vulnerable to age in the home. So as you work through the process, please understand you have a partner in AARP. On behalf of our members, I say thank you for the time and effort on this subject.
Questions, Representative Summers?
Mr. Chairman, Tom, thanks, and thanks for all you do for the elderly. And I feel like I'm getting in that category, so thanks for helping me. So, Tom, my question is, one on the need, and we saw it in the ARPA money, transportation, you talked a bit about that, transportation guardianship. And so I kind of asked that question, you kind of talked about it, but it seems to me like transportation is something we can solve with, maybe without the state's help, hopefully. That's a question I had versus guardianship, which is something that'd be tougher, I think, for the community-based people to get to. So speak to me a little bit about which one you see is more feasible to be funded through partnerships in the community. And then this issue of this definition obviously is critical, right? And I think your input on what you've heard and what you hear on the verbiage will help us as well, because you're going to get feedback on that. I think it's important we hear that feedback because you're likely to get it more than we are. And so those are my two thoughts. We'll need some help on that definition, and give me a little discussion on transportation versus guardianships.
Tom?
Chairman Larson, Representative Summers, two very good questions. In terms of, I'm more familiar with the transportation side in terms of what can be done or what could be done. We've seen a number of things done kind of around the country as well as around the state. In fact, a couple of years ago, just before COVID, our Casper Community Action Team was working on a volunteer ride program. And part of the impetus for that was the fact that the hospital in Casper was struggling to turn beds over because people would be released, they would be discharged from the hospital, but not have a ride home. And so they would end up staying hours past that time. So there was some conversation around that. There was a lot of question about what sort of risk is somebody putting themselves in financially by volunteering to offer rides and things along those lines. So that's something that we are working on. There's a few other states that have done some things around that question of where do your costs lie if you're doing something like that. And we're also seeing the state senior centers do a pretty good job of offering kind of on-demand rides where and when possible. But there is that question about being able to get somewhere quickly, getting to the grocery store, something that doesn't require, that does require a door-to-door sort of service. And I think that's something that you'll see us working on a little bit more in this group itself. The other question was around feedback on the statutory definition of vulnerable adult. And that's something that wasn't necessarily on our radar until this task force was formed and put together. But it's certainly something that we plan on moving forward, because we want our members to understand what their rights are and how to make that sort of work within the law and keep themselves, frankly, in a safe place. A few weeks ago, I was actually called out to a house. We do this. We do an event called a shredding event, which is basic stuff. So it's the concept is if you've got personally identifiable information that you'd like shredded, we'll rent a shredding truck. And in this case, it's 2 shredding trucks. And we'll do a community event where we just have the shredding trucks open, bring your stuff, we'll shred it on site, for free. And we ended up, I think, 475 cars that came in, but we had one woman who called and said, I've got stuff all the way back from 1988. The problem is I'm homebound. Can you come pick it up? So I went to pick it up and we found a situation where she's homebound and not in a place where, there were questions about whether or not she should be there. And I'll tell you, the people sitting behind us, you've got some very caring folks who are working in that realm. I picked that paper up at like 5:30 and made a call to Lee Grossman and Medicaid it, at that point. And by the next morning, we had an application for Medicaid as well as, what services could be provided, at which point we brought in DFS and, that all went into action pretty quickly. So the good news is you got the right people on the bus.
So Tom, just to comment, as you guys are noodling this whole thing around and visiting with the members around the state, it's just important that they know we have no desire to take control of their life, and it's just this balance that we're trying to establish that we want to have clearly in their favor, but feel there has to be a mechanism and through definition that we can help those who need help, but you know how sometimes that can get twisted a little bit, and we just, at least there's 4 of us, all 2 senators, 2 representatives that have we fit that group. And so.
Chairman Larson, I'd just like.
I know there's a conspiracy amongst the others to take advantage of us. So. Thank you.
Chairman Larson, we're happy to use all of our communication tools to make sure that you get the feedback that you like, and leading up to, and perhaps even a teletown hall where we can have someone from this group explain kind of what you're trying to do to them, for the members of AARP and older adults in Wyoming.
Other public comments? Mr. Gardner, come on up. Good morning to you.
Thank you, Mr. Chairman. I'm Jeff Gardner, representing the Wyoming Community Service Providers. I think most members of the task force are familiar with our group, but just in case, we're a statewide group of providers who support adults with intellectual and developmental disabilities in most of your communities. I didn't intend to give comment, but as I listened this morning, the first thing I guess I would comment on is there are 1,500-ish adults who are served through the Comprehensive Waiver Program in Wyoming, and I'm sure many, many others who are not yet identified, but would fall under this vulnerable adult category. So my first comment would be, if we can help in this process, we want to do that. So to give our support and assistance if requested in whatever comes out of this committee. The second thing I'd briefly like to comment, because it's come up several times, is a guardianship issue. That's something that our members quite honestly struggle with a lot in all parts of that. So I guess my encouragement to this group in terms of guardianship would be to look at the current guardianship statutes. It's my understanding that they have not been updated since the early 1980s. And so it's really a very antiquated statute according to some of the stakeholders within our network. And again, WCSP, myself, would be very happy to be a part of any conversation in updating guardianship statutes because, there are things, I appreciated Tom's comment about maintaining, self-direction and autonomy in that process. There's some things currently that are anything but that in our current statute. So with that, I would stand for any questions.
Questions for Mr. Gardner? So I have a couple, Jeff, if I may. We look at your organization and the providers that you represent around the state, and we mainly think of those being served by the comprehensive and support waivers. Do you also provide services for largely adults or others who may not be on services beyond the waivers as well?
Mr. Chairman, primarily our members serve people who currently have a waiver funding opportunity. There are some isolated cases across the state where families are in a position to be able to private pay for services. And certainly some of our members, many of our members, provide some free services to people who, just quite honestly need the help. So, but to answer your question directly, primarily folks who are funded through the Medicaid waiver program.
And clearly we identified these individuals being a component of the overall population that we're having the conversation with. And we could clearly have somebody who maybe has a TBI that is functioning very well, but with the onset of maybe some other diagnosis then fits into a category that would require a waiver consideration later in life. And so having you guys at the table is very helpful. The comments on the guardianship is also helpful. Thank you.
Yeah. And Mr. Chairman, if I may really quickly, I meant to say this as an icebreaker, in that I'm sure that most of you are so happy to hear me sitting here and not talking about money. The director is.
That's why we're sitting down. Thank you, Jeff. Any other public comment? Good morning again.
Good morning, committee. Good morning, Mr. Chair. My name's Ann Clement. I'm the Director of Programs for the Alzheimer's Association, so I'm actually not here to speak on legislation, as that's not my oversight any longer.
So we're going to ask you to slow down
Oh,
just a
I'm
little
sorry.
bit and tell us who you represent again, please.
Apologies. Ann Clement, Director of Programs for the Alzheimer's Association. I've stepped out of my role as public policy, so I'm not here to speak on the legislation that's been drafted, but I am here just to offer that we have been providing community forums across the state. We've met with Laramie County, Campbell County, Fremont County. We've had the opportunity to meet with both tribes. We have a lot of insight into that space as it pertains to the needs for those with dementia-related diseases. So if we can be of any help in that space, please don't hesitate to contact us, and hopefully we'll have this hat filled with another person in the next few weeks, and we'll be able to engage in a more legislative manner.
Thank you. Any questions? Senator Barlow? Oh, okay, good. Good, thank you. Have we missed anyone? How about our online folks, Katie?
Mr. Chairman, I have Melissa Bates online.
Thank you. Melissa, are you with us?
Yes, sir. Thank you, Mr. Chairman.
Welcome.
Thank you. I appreciate the opportunity to speak with you today. I am here as a private citizen. I work in mental health care in Sweetwater County, but I'm not representing an organization in this capacity. I do the boots on the ground work with folks with behavioral health issues in Sweetwater County and have done so for the last 20 years. I appreciate the conversations regarding Title 25 and how that's used to get people, to get vulnerable adults the care that they need. One of the gaps in Sweetwater County is in being able to provide the actual psychiatric care to people who are on Title 25 for mental health issues. We're holding people on Title 25 for weeks or sometimes months because we can't get them transferred to the appropriate level of care. And we're missing facilities here on the western part of the state to do that, beyond the state hospital, which we know is overwhelmed. One of the ways that the governor's mental health newsletter this month proposed to mitigate that is to encourage use of behavioral health integration programs, which pulls together primary care and mental health care for patients. I'm a behavioral health manager in a family medicine clinic. I run a BHI, or behavioral health integration program. One of the gaps with that is that Wyoming Medicaid does not cover that service. Medicaid in other states do cover that service, including in Montana. So it's possible. I think it's just one of those gaps in coverage of behavioral health care versus physical health care. Behavioral health integration is just support in between appointments and helping patients make it to those appointments and get their meds. So it helps with those things like you talked about, somebody's not taking their medications or, and that's creating problems for them. Another area of healthcare disparity in this part of the state is that while we're talking about vulnerable adults and particularly our aging populations, we talk about use of COVID money. And I know that the population most affected by COVID has been people over 65. They've been homebound. We know that their depression rates are higher. They're not able to get out and access care. And we have in Sweetwater County one counselor, not one agency, but one counselor who can take Medicare. So that counseling piece for mental health to help with that depression, to help with our risk of suicide is something that I think maybe while we're thinking about funding community mental health agencies, we think about whether or not they're allowing those services or furnishing those services to vulnerable populations.
Okay, so let me make sure, I want to ask a question on, you made reference there, Melissa, to COVID dollars into one counselor, and that one counselor that's eligible to, that is enrolled as a Medicaid, you said Medicare, but I would probably Medicaid provider?
This was actually Medicare, so everybody over
Medicare.
65 would have access to Medicare. People with less money would have Medicaid as well.
And so is that a result of other counselors just not wanting to take those patients, or?
Yes.
Yeah, so it's a profession-driven decision perhaps rather than a state-driven position, is that, or am I not seeing that accurately?
My thought is both state and county money is funding community mental health agencies to provide care for vulnerable adults. So that may be an area I don't know if there are areas for requirements for those agencies that are receiving funding that they offer equitable care.
Thank you. Maybe we can ask Director Johansson to opine on that just a little bit.
Mr. Chairman, thank you, and Ms. Bates, thanks for your testimony today. Just a question, you had mentioned behavioral health integration models. Just for my own education, with some of the issues you mentioned in Sweetwater County, Title 25 backlogs, the inability, lack of access to certain types of providers, psychiatrists, clinical psychologists, et cetera. How does that type of model, whether there's a pay source for it or not, and we can certainly look into that on the policy side, whether it's Medicaid or other payers, how does that type of model address those problems? Is it more of a long-term, the hypothesis being, we through that type of integrated care, we will prevent, escalation, or when you have somebody going through a higher level of care of that system, what are your thoughts on that model's efficacy there?
I think the idea is that when we don't have access to those higher level providers, so in Sweetwater County, we don't have a psychiatrist. We have a couple of psychiatric nurse practitioners who practice via telehealth. When we don't have those services available, primary care providers, family doctors have to provide it, or we don't have it. So behavioral health integration helps make those connections. We're working on getting access to psychiatrists who will consult with our providers to provide that care. So in rural areas where we don't have the people with the specialists, behavioral health integration is more of a nursing position that helps pull together the services and then provides case management for patients.
Thank you. And keep up the good work.
Thank you, sir.
And just a note from my co-chairman here, just to note that we, our legislation this year to allow licensed professional counselors to bill Medicaid starting in 2024, I think is a step in the right direction as well. Okay, Melissa, any further comments?
No, sir, thank you.
Thanks for joining us today. Katie, anyone else? Okay. It is 10:17. I think we're going to go ahead and take about a 10-minute break, and then we're going to get started with you, Elisa. Okay, so let's be back in here at, we'll get started by 10:30. You ready? Okay, I think, are we back on, Katie? So thank you, everybody, for on the first portion of that, on our vulnerable adults. The second area that we're working on in this interim is to divert people who find themselves in legal affairs and that also have mental illness, and how do we divert them away from the judicial system and get them the help that they need. And so we're going to turn this portion of our meeting over to Elise Butler to kind of share with us some thoughts and ideas on how we can do that. Mrs. Butler.
Thank you, Mr. Chairman. So this diversion project came out of a 3-branch initiative. So recently, a number of us made a trip to Miami where they have a diversion model that is considered the gold standard in the United States in terms of diverting people away from the criminal justice system. So I'm going to lean in. I don't know how many of you have heard Chief Justice Fox speak recently, but one of the things that she says consistently is the courts have become the emergency rooms for all of society's ills, and that is particularly true for behavioral health needs. And since I have Director Johansson sitting right next to me, I'm going to lean into that metaphor just a little bit. So similar to an ER setting, a patient comes in with maybe dangerously high blood sugar. You treat the patient there in the ER and then you let them go without addressing the underlying issue. And without addressing that underlying issue, what's going to happen is you're going to see that person back in the ER over and over and over again. That similar thing is happening in the courts right now. So we are seeing defendants committing low-level misdemeanors. They are coming into the court system. We are managing those, or we are addressing those issues the way we always have with the court system, which is you charge them and you put them in jail often. Sometimes they have to go through a competency evaluation process to ensure that they can move forward with the court proceeding. And then after they serve their jail time, they are released and back into the community without addressing the underlying causes that created the issue to begin with, or the problem. So this causes a number of problems, clogs the dockets in the courts. It results in people being in jails for entirely too long. It clogs up the state hospital with competency evals, and really has been ineffective, what we've seen in our courts. And so this diversion project really is an attempt to try to address the underlying issue. So just a few facts. In 2022, and I am going to steal some data from the Department of Health here, there were 467 competency evals conducted. A competency eval occurs when a person comes into the criminal justice system and for whatever reason, they are not competent to stand trial. There is some idea that the person cannot help with their defense. They do not understand the charges against them. And in the criminal justice system, with due process, we cannot proceed with that trial until we restore them to competency. So what happens in those circumstances is the judge will order a competency eval. Often that is done with the state hospital, I think almost entirely through the state hospital. And so sometimes that is done on an inpatient basis, sometimes it is done on an outpatient basis, and this happens for all criminal levels. So whether it's a felony or a misdemeanor, we have to ensure that that person is competent to stand trial before we charge them, before they move forward with those proceedings. So there are 467 competency evals conducted by the state hospital in 2022. 105 of those were inpatient, 362 were outpatient. And the wait time for those two is drastically different. For inpatient evals, we're looking at a wait time of 157 days. For outpatient evals in 2022, it was 43 days. So thinking about that in terms of these misdemeanors that come into the system, oftentimes, as I said, they are for low-level crimes, very limited jail time. And so when they come into the system and they are not competent to stand trial, or there's some question about their competency, and eval is ordered, they will sit in jail for that period of time. So if you're looking at an inpatient eval, that could be up to 157 days. Often they are sitting in jail longer than what their sentence would have been if they were convicted. And so it's created not only a bottleneck in the state hospital, it has created a bottleneck in our jails across the state. So 28% of those evaluations were for misdemeanors, and 61% of those were found competent to stay on trial after that competency eval process. And again, what happens often is they're found competent to stand trial, they are potentially convicted, and they're released for time served, because again, that the jail time is less than the time that it takes to go through that competency eval process. And so they're released back into the community again without addressing the underlying issue, which is usually a behavioral health, mental health issue. So the goal of this project is really to look at a way to divert these folks away from the criminal justice system early so that they can get the treatment that they need and the services that we can provide. So there's a number of different places to divert when it comes to the criminal justice system. The first place is, well, I'm going to not talk about ground zero. I'll talk about the first place, which is where they have contact with law enforcement. And so law enforcement, one of the projects here in Cheyenne is called the LEAD program. And what happens in that program is a law enforcement official sees somebody or is called and somebody's committing a crime, usually a low level misdemeanor. And at that point, the law enforcement officer has a decision to make. Am I going to take this person to jail, book them, or can I divert them to treatment services in the community without even booking them, without even having a contact with the court? And so that would be the first level of diversion, and that takes some training with officers across the state. It's crisis intervention training, and I think a number of agencies, law enforcement agencies across the state have officers who have gone through that training. The second place to divert is what we're really looking at here, which is pre-adjudication. At least that's what we're looking at within the judicial branch. So pre-adjudication, when they come into the court system and they are charged and they see the judge for the first time. And at that point, we would be looking at whether or not this person is qualified for diversion, and we would have to determine what that looks like. And if they're qualified for diversion, instead of going through an adjudication, a competency eval, all of those steps, we would divert them right away to treatment services to allow them, again, to address the underlying issue that they're experiencing that is bringing them back into the court system time and time again. And then the final diversion point is post-adjudication. And we actually have a model for this already. Those are our treatment courts throughout the state of Wyoming. And so post-adjudication, if somebody is convicted of, say, a felony, instead of serving maybe a substantial amount of jail time, they will go through the treatment court program, which again provides them with services, tries to address that underlying issue to prevent them from coming back into the criminal justice system. So this project is still at the very, very early stages. We're still planning. What we're looking at right now is potentially using Campbell County Gillette as a pilot court. So these would be low-level crimes, misdemeanors, where we could, again, divert these folks to services without providing, a threat to the community. We're working with stakeholders now, Director Johansson, and the prosecutors, public defenders, judges, sheriff's office, and then community mental health providers in Campbell County to try to determine what we can do to move this project forward. The benefits of a plan like this is it'll help unclog the courts. It helps reduce the time that defendants spend waiting for competency eval. It reduces the load on the state hospital, which is substantial, as we all know. And then it will also reduce the jail population. So I think what we've heard consistently as we've traveled the state and talked to sheriff's offices across the state is they are not well equipped to handle people with behavioral health issues. And so they are having to shift and adapt to the need that is they're currently seeing in the jails. And so with this project, the hope would be that we would be able to reduce that population, reduce the burden on the courts, on the law enforcement officers, on the jails, and on the state hospital. And so, Mr. Chairman, I'd be happy to answer any questions, but that's kind of a broad overview of what we're looking at for this diversion project.
So, Elise, can I maybe say that a little bit different in looking at that for the folks that are watching? Yes, it will reduce impacts on courts, and yes, it will reduce congestion at the state hospitals and in jails, but more importantly, rather than punishing people through the court system, we're trying to get them the help they need. And that's the ultimate goal. The additional benefits are these reductions in courts, jails, and that's just the number one motive is how do we help people, right?
Mr. Chairman, yes.
So, Director Johansson, do you want to follow up any on this conversation before we start asking questions?
Mr. Chairman, just briefly, I think it's important to say, similar to the discussion at the recent Mental Health Summit in Casper, from the Department of Health's perspective, the engagement and the leadership from the judiciary through Chief Justice Fox, Justice Fenn, Ms. Butler, so many others that are wanting to do something about this issue. It's just really positive. And the Department of Health, as you mentioned, we see symptoms of a larger problem with clogged up courts, clogged up jails, clogged up state hospital that are indications of a broader issue that we're not providing care or services to people in the best way that we could in some of these circumstances. So this pilot project that Ms. Butler mentioned, we are very excited and optimistic that we don't have all the answers right now, but we will be able to implement something that will help folks going through the judicial system whose primary need is really not in the judicial system. It's in mental health and social services. The folks that we have rallying around this project, I think, can put something in place that can at the very least be a learning experience for the rest of the state that we could model on the tail end of conversations this task force will have of the best way to solve some of these state problems for those most in need, and really queuing up what I think will be a good early experience with a more comprehensive and broader effort that we're engaged in and have been with our community providers for a number of years to fundamentally redesign the community behavioral health system. This is an excellent part of that, or test case for that, of what the state will need to be able to deliver some of these services in a different way. And again, reiterating your point, Mr. Chairman, there's policy issues here, there's cost and economics issues here, there's a lot of logistics that we want to solve to make things run more efficiently. But at the bedrock of that is there's a moral issue that we all see it at the state level and in our communities, that we're seeing people in scenarios and in settings that we can improve through a few tweaks. So I just appreciate Ms. Butler's overview and the judiciary's engagement, and hopefully the Department of Health and our other agencies and Department of Family Services and Corrections that are involved can deliver on this. Thank you.
Okay.
Mr. Chairman, thank you. And so I want to understand this in the context of the meeting materials I had, which is the Miami-Dade mental health project stuff that you guys went and viewed. And so in that, they had a pre-booking diversion program. So that is not what we're talking about. My guess is this is a post-booking diversion program. That's my first question.
Mr. Chairman, Speaker Summers, I don't want to rule out the possibility of pre-booking. What I would say in that context, though, is the courts don't have a role in that necessarily, except for to gather folks and say, hey, this is a good idea. So from the perspective of the court system, and what I would say for this pilot is that is absolutely correct. We're looking at post-booking, those folks who are charged and go before the judge. But I would hope, with the CIT training and some of the other programs around the state, that we can build up the capacity to have you know, a law enforcement diversion as well, where when they come into contact with law enforcement before they're booked, that they will be diverted to services. But I think that's probably a little bit down the road.
So, Mr. Chairman, that kind of follow-up, that kind of leads me to my second question. One, I think you kind of answered it, but I'd like a little more, I'd like to hear a little more about it. So the crisis intervention team, as I read the materials, seemed to be really key to this. And then the ability to have some crisis stabilization units. And so talk to me about what we are doing in Wyoming with respect to the crisis intervention teams. And then do we have, I'm assuming we have very limited crisis stabilization units, but I don't know what that means in respect to Wyoming. So if somebody could answer that, I'd appreciate it.
Mr. Chairman, Speaker Summers, good and big questions there. I'll take them in order. Building on what Ms. Butler said, I think whether we talk about pre-booking or post-booking, from my simple mind, I explain it this way, that we are looking in a pilot project to take certain low-level misdemeanor offenders who meet certain initial screening criteria where we're really looking for certain types of mental illness that's potentially there. So we're looking at low-level crimes where, you know, the de facto right now is crime is committed. Let's say it's a low-level misdemeanor, person's held in a detention center, and the only game in town, the only service the court has access to is an evaluation from my state hospital, or subsequently ordering for services at the state hospital. Where somewhere in that process, the idea here is to, in partnership with law enforcement and the court, take a subset of what comes through the Title VII, judicial system, and identify folks that would be readily eligible or would benefit from, outpatient services versus services from the state hospital just through competency evaluation or inpatient treatment. And I think to get to your question about CIT on the front end, any model that you read on diversion heavily relies on that first interaction with law enforcement. In terms of CIT in Wyoming, it's variable of how communities implement it, but it is, I would say, relatively widely used as a concept. But where the breakdown comes, to now get to your second question, is CIT could happen perfectly and hypothetically. And law enforcement officers are trained to notice this is potentially a mental health call, or de-escalation might be needed, as opposed to more traditional law enforcement techniques with a criminal. But where do you go? Where do you take this client or this individual that's in crisis? We have limited crisis stabilization facilities across the state that the state funds. I don't know the number off the top of my head, but we can certainly prepare it for the committee. And capacity in those is also variable, and some are full and some historically have not been full. That's a big element of our ongoing redesign, to look at our residential capacity for the priority populations that have now been statutorily established, of which those are acute psychiatric individuals, think Title 25, criminal justice involved individuals, so think this population, Title VII, and other local corrections involved clients with mental health needs, high needs children and their families, and some high needs low income indigent. The idea being, over this next year of implementation of that redesign, really taking a hard look at how that, even if it's limited, how that residential capacity is used and can be used, and how it's paid for to support that new priority population. But long-winded way, Speaker Summers, of saying, I don't think we have everything that's needed in the state to do the Miami model full bore right now and just flip a switch and turn it on. But I do think, the discussion's interesting, because I do think Wyoming has mental health, substance abuse capacity, outpatient and residential, through our wonderful partners and providers in the community that can do this work. Doesn't mean it's perfect, doesn't mean it won't require additional resources, but I think getting our feet wet and testing this model, knowing that we have some shared objectives with our judicial system, with our law enforcement and jail and detention centers, with the state hospital. So many areas of public policy and service that this impacts, where the wait times, the wait list, the service breakdowns are causing all of us to raise our hand and say, yeah, this impacts us too. This impacts me. This impacts our budget. I do think we can leverage the support that we have through those folks and through our providers to test. And as Elisa mentioned, we're talking about in the short term here, but it's not fully baked. It's not ready to go. We're not turning this on next week or next month. It really, I think, will involve some education with those folks in the pilot county to understand what we're all trying to achieve, and then look at the resources we have currently and see what parts of that model, to your point, can we do full pre-booking to post-booking, this whole continuum? Maybe not, but can we take a subset of that population, identify them for diversion, and serve them not only at a cheaper cost than inpatient or a detention center, but in a more humane way that might generate some better social outcomes. So I think it's looking at a piece of the Miami model, piloting that or those pieces in one area, which will point out, I think, to us and the folks that are involved, where are those breakdowns? Did we need, in that area or regionally, did we have access to a crisis bed when needed, or a residential bed? Or did we have the appropriate, psychiatrist or clinical psychologist in person or via telehealth? A lot of that learned experience, I think we have to dive in to get, or we'll plan it for 5 years, and additional problems will come up. So I hope that answered some of your questions. I know it was meandering, but it's a big issue.
Mr. Chairman, thank you. And now it's been a few days since I read this, but one thing that I thought I read in here in the Miami model that seemed to me to be something that really made sense, really hard to do, but it's really, almost how do you fold in a DFS type thing? In other words, how do you, providing mental health support is great, right? But if you don't have either community support or institutional support to get that person a job, if they need a job, help them retain a job if they have a job, those sorts of things that that really will make a difference in that person's life long term. So as you look at this piece in Gillette or in Campbell County, are you looking at the backside of that as well? Or are you going to look at the backside?
Mr. Chairman, Speaker Summers, I'm really glad you asked that question. Answered in two ways. In terms of this pilot, yes. And in the last 2 months that we've been working as a team across branches of government to stand it up, and certainly don't want to speak for the Supreme Court or the judiciary, that's been identified. That's an absolute need. So the services are one. The diversion is one thing. The services are another thing. But that's sort of community engagement, case management, whatever term you want to use, to not only coordinate, services and the appointments, but care about those social issues that we know are so correlated to the outcomes of these cases, is something we know has to be a primary responsibility within this program. Looking at this population, we know that stable housing is an issue, and that problem won't be solved, by a coordinator or by a program to suddenly start building housing stock, but connecting to resources, helping someone navigate what those housing assistance programs might be, knowing that they're limited, employment, volunteering, those types of services that we know are available, again, in some limited capacity across our communities. We want someone helping navigate a person, trying to help navigate or assist a person to better those social outcomes. It's almost, if not more important than the actual services, the medication management, the counseling, the therapies, are those social issues. Secondly, again, this is kind of a part of the concept of the larger behavioral health redesign that you all legislated a couple of years ago, that we're in the process of implementing in this final year. Those we will be incentivizing and rewarding providers for delivering on social outcomes, like not being in the hospital, not being in jail, being housed, being employed. That is in the process of design. I'm looking at Ms. Somerville, who's who's smiling and winking a little bit because we have a lot to do in terms of that payment model design. But I'm really pleased with where we are and where we've come over the past couple of years to implement that redesign and those social outcomes, what you hear folks in the field refer to as the social determinants of health, are very much a part of this redesign. And Wyoming's in a position to really innovate how we incentivize, how we incorporate those into our payment model, because nobody, no system really has a good answer to that. Those issues with housing, with employment, with social determinants are always a huge part of a problem, and they're not one person's responsibility. So that makes it very difficult. But I think with anchoring a resource in a community that can maybe not do everything, but be that bedrock to care about those social outcomes and to have some upside reimbursement on achieving those social outcomes could be a model that we will test over the next 1 to 3 years, its success.
Thank you, Mr. Chairman. I just wanted to add on to what Director Johansson said and maybe get at some of your questions, Speaker Summers. I had the opportunity to go to Miami with the team and look at this model, and I was really glad that I had the opportunity to go. To me, it was very exciting because it is built around such strong community partnership under really strong leadership from the judiciary, like our treatment court model, but even kind of more than our treatment model, and just a real dedication to getting folks treatment versus jail time, and really focusing, like the chairman said, on we want to get people into treatment. From the Department of Corrections perspective, we are in many ways a human service agency and appreciate being at the table for this task force for all of our topics. And so we're part of the state level discussion on this model as well as locally in Gillette. And I think we can't underestimate, and this is what the director was touching on, the power of good case management. A good case manager can move mountains, whether we're talking about vulnerable adults or we're talking about adolescents or we're talking about folks that would be coming into this model. And so I think that's a critical piece as the task force goes on later and we start talking about maybe some of the how is just that person that's really coordinating this at that very beginning stage. And in that Miami model, that was very clear to me, was that if you don't have someone who is working with that judge and the prosecutor and saying, getting that person into services right away, it just was key. So I just wanted to stress that case management through the whole agenda today is really vital. Thank you.
Thank you, Mr. Chairman. So I'll be involved in the Campbell County things. We actually had several meetings already in our community, and now the Chief Justice is coming up soon. But my question is, because this is a post-booking intervention, if you will, or diversion, what statutory changes does the courts need and do prosecutors need to actually implement this? Because I don't see any bill drafts right now that go to that. So we can talk about having a pilot project, but it seems like, what statutory authority do we have to have some of this pilot project? Or is this, are we going out on anyway, I'm just asking, because if we're talking about post-booking, then there is a charge being filed. And right now, we have some other programs in statute that allow outpatient commitments. That's under Title 25. We also have something in the criminal statute about, I can't remember what it's called now. You don't go through the prosecution. You have a chance to. The 311. Is that the right? Anyway, there's some other things, but. So do we need some statutory, is there a need for statutory changes for this post-booking? CIT, pre-booking, that's different. That's different. And I'd pour tons of resources there. Personally, I would pour tons of resources there. And we have some. But post-booking, what do we need statutorily? Thank you, Mr. Chairman.
Well, and before, just yesterday morning, I met with WAMSAC in my community and was reviewing these issues, and that indeed was one of the comments that come up is we look at that under current Wyoming law, there seems to be some challenges there, even in pre-booking or post-booking. If the crime's been charged and they commit it, what's the decision here, right? And so I think hence, that's one of the reasons we're having this task force, is to identify and determine what and prepare to address that. And so I don't know, Ms. Butler, if you've had a chance to give any consideration to how that might look, but you could share that with us. But I think we're all on the same page as we need to get that figured out.
Mr. Chairman, Senator Barlow, so I think we're still at such early stages that we haven't identified which statutory changes need to be made, if any. One of the things that we do need to think through is that criminal justice process, and a lot of that is criminal procedure, and so that's by rule as opposed to statute. But as you all know, when you're charged with a crime, you have a right to speedy trial. So there's so many days in which, you know, you have to be brought to trial within 180 days unless there are certain circumstances that apply. And so as part of this, there is going to need to be some consent on the part of the defendant to be diverted. We are not going to be able to force anybody into diversion. And so as part of that, the defendant is basically going to consent, or at least this is big picture how I would imagine, consent to a waiver of speedy trial. And then the judge says, okay, we're going to hold your charges until you go through this treatment. And then we're going to have check-ins similar to what we do with treatment courts, you know, at various times to determine whether or not you're meeting your treatment plan, whether things are going well. And, you know, if the treatment plan fails, if things are not going well, those charges are still there. And they would come back into the court and proceed with the criminal justice system. And there are absolutely going to be defendants who decide not to go through diversion. There is no way for us to force that. And so if they come into the criminal justice system, they are given the opportunity to divert before they are adjudicated, and they decide not to take that opportunity, then they'll go through the regular criminal justice process, which could include a competency eval, it could include just a trial or even a guilty plea. And so, you know, we're still working through, I think, some of those issues, but the big things that we're going to be looking at are more in terms of the criminal procedure, and there may be some statutory changes, but I just don't know what those are right now.
So just as we contemplated and made the decision to do a pilot project in Campbell County, we had 2 district judges from Campbell County that were there, and so that helped us with their understanding. But Director Johansson, this question I'll guess to you, because my observation was there were other states, Rhode Island, Utah had some representation there at the meeting. As we looked at this model of when you divert, who then provides those services was a key, right, Director Schmidt? Who's going to do that? And I think we were pretty pleased because of the behavioral health redesign and the work of the community mental health centers, that seemed to address that on these lower misdemeanor type cases fit into what we envision our community mental health centers doing, which then am I seeing that the same way you interpreted it, and does that give you confidence on this pilot program that at least we can move forward with and refine the process and get the answers that we're looking for?
Mr. Chairman, not to be Pollyanna, yes, as I mentioned, I'm very optimistic about this, and primarily that's because I have a lot of confidence in our mental health providers. There's longer term, you know, implementation going on with the behavioral health redesign, and so this could be, again, timing is still being planned, but this could be an early adoption of that in a very targeted and smaller way. But yes, your understanding was the same as mine from what we observed on site and what we learned from the various folks in Miami-Dade who implemented a model like this, you know, 20 plus years ago. Their lessons learned were so they indicated to me that we had some of the bricks and building blocks laid in Wyoming already with our facilities projects that have been completed, with our behavioral health redesign, with some of the changes we've made on Medicaid side over the years. I do think we have the foundation to make something like this successful. But I also believe that with changes like this, as Ms. Butler mentioned, there's a lot of ins and outs and what have yous to consider here because it's a different way of doing business legally and from a service delivery perspective. But another long-winded answer, Mr. Chairman, but yes, I'm optimistic that we have the pieces in place to make this work.
So the other part of this conversation that I want to have that we heard in Miami that was critical, and you've heard it thus far today, committee, is the importance of the crisis intervention team and the training and the mobile intervention teams. And we heard that over and over in Miami, that you've got to have how you approach these people to begin with and make those assessments are really critical. And so we started asking that questions. Jen Davis, just informational for you, as Jen Davis in the governor's office reached out and asked around the state where law enforcement agencies have ongoing or plans or historically done CIT training. I think it's a fair representation to say that's spotty around the state. That in some areas where it has happened in the past, may not be currently being taking place ongoing. Places I think probably most successful be in Campbell County, where they've kept up with that. They have CIT training and they have a mobile intervention team that really fits that need. One of the, it's a 40-hour course. Natrona as well, thank you. Yes, it's a 40-hour course. It is not offered in post-training at the Law Enforcement Academy. We had one of the reasons for not doing CIT training, of course, was funding, but we have funding available now through the Department of Health through some ARPA dollars. And Mrs. Shippen has provided some documents on that training, but Dawn, if you would just kind of share with us, I think, again, your information or what you discovered is that still has been, is those funds are available for our law enforcement people to provide this training, but perhaps they are not aware that funds are available to do that because it's maybe not being taken advantage of to the level we thought it would. So could you just share with us what you've come up with on that, Donna?
Mr. Chairman, the Department of Health was helpful this past week and provided information about the grant monies that they make available through the Wyoming Association of Sheriffs and Chiefs of Police. So there's a grant that's just under $1 million that started last year, about a year ago in March of 2022. It's this is grants that law enforcement agencies in Wyoming can apply for to provide CIT training to their officers. It's entirely voluntary, though, not required. And I did get some information from WASCOP, the Association of Sheriffs and Chiefs of Police. And to date, since the grant started, there are 15 different town, city, county law enforcement agencies that have taken advantage of that grant opportunity, and a total of 119 law enforcement officers trained. This is in your meeting materials. It was sent to you in an email, so it's a little spreadsheet, and it looks like about a quarter of the grant monies have been spent to date. And then WASCOP also provided a copy of CIT learning objectives or their curriculum, and that I provided hard copies you should have there at your seat. And it goes through what the training involves. It is 40-hour training. It takes a week. But that's what I have.
Thank you. Any questions for Donna? I think committee, one of the things that we ought to be contemplating or thinking about as we drive around the state is, do we need to make that mandatory law enforcement training? I mean, is it as critical or not in that, and who to? And I don't know how that looks, but I'm just, I think it's a question that this committee really probably ought to answer. Director Johansson.
Just to comment on that, since we've delved into this over the years of what CIT is, how it gets implemented, I would just mention for the committee's awareness when considering something like that, requiring CIT of law enforcement can take many different tracks. And we learned in Miami, and certainly from other jurisdictions. I remember working with Senator Barlow years ago on Title 25 and some of these issues surrounding CIT, and there's agencies around the country that have been successful with targeting CIT to a select group of officers that really are part of a response team that maybe handles those types of calls versus universal CIT training that might be required in the academy or from that law enforcement agency in particular. I don't think there's one model that we can point to that says this is the way to best do it to achieve the objectives that we're talking about. So just something for the task force here to consider, that what that requirement or what that incentive might look like.
Senator Barlow, any thoughts?
Mr. Chairman, so I would say certainly we should incentivize as much as we can, and we could take that 72 hours for Title 25s and just add a day. They're responsible, they're responsible for that cost if they're not CIT trained. We just keep adding it. That's a disincentive. But the point being is that there are real advantages to handling this earlier in the process. And some of those, quite honestly, these governmental agencies, they will be the beneficiaries of that. They will be the ones that have the reduced recidivism, the fewer turns in the style, et cetera. But it's absolutely critical. Thank you.
Mr. Chairman, I also wanted to mention, as did Heather, about the Department of Corrections, the Department of Family Services role in all of this. And I particularly want to call out the CIT curriculum and how it also addresses crisis intervention for adults or for adolescents and youth. And I think that's an important conversation to have and note that a lot of this type of work is really going to help us also in addressing those crisis situations where we have children and adolescents who have severe mental health needs that are also coming to the attention of law enforcement, because oftentimes that it can start there too.
So, Mr. Chairman, perhaps at our next meeting, we can try to get the sheriffs and chiefs here to have that discussion about what their capabilities are and what they need, and I think, ultimately goes to, the Miami-Dade thing. They have a program, right? They have a process. At least we need to, I think, help develop frameworks in Wyoming, whether they're used or not. We can develop some frameworks that may be worthwhile. And I think in that framework, you can plug in DFS, you can plug in a variety of Department of Health, a variety of people that can help in that process. And, one thing that caught me in the material that was so evident that I would never even have thought of is a lot of these people are not even hooked into Medicaid, right? Not even hooked into the basic need the basic service that we would allow. They're not even hooked into it. And so I think how we get all of that done is really important. But sheriffs and chiefs need to be at the table.
Mr. Chairman, I drove in the rain last night and the snow this morning from Laramie. Thank you. Andy Somerville, Executive Director for WAMSAC. And I just have a few comments. Certainly, we're a partner, an excited partner to talk about this diversion program. As we lean into behavioral health reform, we talk about 988. We talk about the idea of getting to these folks earlier in the process. This is what we're talking about. This is what keeps them from being at the high level of the scale that take a lot of resources, but it's also costly on them and their families, right? They might have to leave their family, they might lose their job, et cetera, et cetera. And so anything that we can do to move that acuity back down the scale is really, really, really important. We certainly want to lean in, and we are leaning in. All of our community mental health centers on the pre-booking side already. We're working with a couple of different counties on trying to put some additional mental health support in the field, working with law enforcement and some communities to try to work on that pre-booking diversion. That's a long project for Wyoming. We will probably never look like a Denver, Colorado model, but we're working on that. The post-booking side, though, is also incredibly important. One of our biggest complaints that we get from sheriffs is these folks are sitting in their jails, and they're sitting. Whether they're waiting for a Title VII evaluation or something else is going on, that's not the appropriate place for them in a lot of circumstances. So this offers an opportunity to really, I like the way the Director of Department of Health put it, a learning opportunity to dive into this a little bit as we, again, try to dovetail all of this into behavioral health reform. There's a lot of moving pieces right now, but we are fully supportive of this project. To Speaker Summers' questions about resources, I did want to let the committee know we do have, so crisis stabilization, we don't have a lot going. We have about 35-ish beds approximately that are online right now, and they're in Cheyenne, Worland, Rock Springs, and Casper. What I will note for the committee is that the State Land and Investment Board, through generous funding, has approved some dollars that are going to up those numbers. So we are going to put, let's see, 4 more in Cheyenne. So that'll bring Cheyenne's beds up to 12, and there'll be 12 new beds going up in Sheridan. The intent is to have those up by January 1 of 2024. So we are slowly building capacity, and our crisis stabilization system right now in community mental health is regionalized. So that does include it, and we consider transport and moving people around as necessary to take advantage of those resources in that system. So while we certainly probably will have to have discussions about resources in the future, we are slowly trying to add some of those. And Mr. Chairman, the last comment I wanted to make was just on the CIT training. Law enforcement is a critical partner in any type of diversion program, pre-booking diversion program, out in the field, getting folks into resources. I'm going to lean just for a second on an old job that I used to have and say one of the challenges with getting a lot of officers trained is that they have to be taken out of the field for 40 hours to attend CIT training. A lot of cities and counties don't have replacement officers necessarily. So certainly there are some logistical challenges there as well for those departments to move forward and get those officers trained. But we do certainly hear a lot of interest. Our community mental health centers provide that CIT training in communities all across the state, and we certainly have done a few more. I think the director of one of my agencies personally did 2 of them last week because it was an urgent request from the department. So we think that that's an incredibly important piece. We think that having officers CIT trained is going to be a critical component in however we put together what might look like real mobile crisis in Wyoming. Those officers are going to be critical. Certainly that CIT training is the base to start. So we appreciate the work that's been done on the cross agencies and moving this forward, and we're excited to help and be part of the process. And Mr. Chairman, I would stand for any questions.
Speaker Summers?
They eventually quit turning my light on, so. Thank you, Mr. Chairman. My question to you as a representative of the community mental health centers is, all of these programs, all of these methodologies, everything's great if you have capacity, right? If you don't have capacity, then none of it works, or it doesn't work well, or it doesn't work as timely as it should work. And so what I hear at times is perhaps your wait lists, your wait lists are high. I don't know whether they are or not, but I hear that. And when it goes to ability to hire professionals that want to live in little towns in Wyoming, and then it goes to pay. And so, you know, talk to me about your capacity. Talk to me about how we can improve your capacity. I'm not sure that money's the answer if you can't get people to live in places. Same thing with schools, right? It's hard to find teachers that want to move to some of these communities. So how do we crack that nut? Because if you don't have the people's ability to react at the time that they need to react, it doesn't matter how good the process is you create.
Mr. Chairman, Speaker Summers, I think those are all very important points and things that we've been talking about. Certainly, the community mental health system in general through the pandemic has taken a beating in terms of staffing, just as many other healthcare agencies have done across the state. And it's certainly been an issue. I will tell you that we do sometimes have wait lists for our residential beds. That comes up. We do try to move our outpatient services and our crisis services as quickly as we can. And a lot of it is right now just strategy on the ground within each community mental health center on how they allocate those resources and move folks around. We have seen some innovative ideas and approaches come up in the last couple of years. Community mental health centers working directly with private providers to try to improve that capacity, doing some contracting. In fact, we think that's going to be pretty important as we move through behavioral health reform, and we now have this new prioritized system of access. And trying to, a private provider might be comfortable providing on-call twice a month. It might be something that they're interested in doing, but they still want to maintain their private practice. I think we're on the ground working on more of those things. I would say that the legislature moved a few things that we asked them to last year to get at some of the workforce issues. So the LPC compact and the SIPAC that were passed, those are both really, really important. Particularly the LPC compact in terms of trying to keep those providers in those small rural areas. Realizing though that that's going to be an ongoing challenge. Regionalization in the community mental health system is important, and telehealth is going to become even more important. So you may find that we're back talking to you about not necessarily money for operations, although salaries and what we pay our mental health licensed clinicians is a different discussion. What we might be talking about is broadband access, trying to make sure that we can get access to folks when they have to use telehealth as the alternative. I think that that's going to be part of a bigger discussion going forward in terms of how we cover that. The last point I'd make is, again, this is within the community mental health system, is we've seen a significant change in the last 3 years. When I started this job in 2019, there was 19 community mental health centers. Today, there are 10. That's not a bad thing. What it is a regionalization thing, so that these tiny centers that we're trying to operate exclusively on their own, everybody's trying to recruit their own staff and serve their tiny piece of Wyoming. They've banded together to create slightly larger organizations. That has allowed administration burden to be lifted and a little bit easier. It also allows them to deploy resources to their counties a little bit differently to try to make all that move. Mr. Speaker, I don't, besides talking about money and capacity and how those pieces flow together, we don't have any specific requests today on terms of additional workforce. I guess I would be remiss to say we're also working with the University of Wyoming and our community college system on some different type tracks that would allow us to offer educational advancement for those that are already working in the mental health system. So for example, if you're working as a residential tech at one of our facilities, you have to have a high school diploma, clear a background check, et cetera, but you don't have to have any higher credentials. Setting that system up through our community college system and through UW, that while they're working for us, we can take them through and get them trained if they want to work in the field. So we are working on that as well.
Follow up. So really, this question is for Director Johansson, and it is oversight of these mental health centers. And do we track caseloads? Do we track wait times? Do we do enough insurance that the money gets down to the ground and doesn't get tied up in the administration? And so what do we have for safeguards and to ensure that money gets to where it's at and that we understand at a state level, we can comprehensively understand what our need is.
Mr. Chairman, Speaker Summers, it's a good question with a tension that I'll try to articulate. So the simple answer is yes, through our contracts with the mental health centers for what the state funding and the federal funding that we pass through for what that purchases, we track that very granularly. To your other question, again, pointing out that tension is how do we ensure the money gets to the services as efficiently and effectively as possible? And that's one of the bigger components of the behavioral health reform is to look at how can we reduce administrative burden both on the state and on the providers while maintaining the knowledge that we need for how this population is being served. This happens in numerous government systems and relationships with contractors and providers where over the years we've collected and tracked things that may be less relevant and maybe think of all the things that our feds and CMS make providers report and track, and there's value to a lot of that. And then there's some areas where you would see not as much value and efficiencies that we can find. We're engaged in that work with the providers to see in this redesigned system how we can reduce that administrative burden so that the vast majority of the funding goes to the care that's being provided to individuals. But through the years, and we can easily produce this for this task force, show the outcomes and the data that we track with the mental health centers. But I'm optimistic over the next 12 to 14 months, we will find areas in the redesigned and reformed system that ensure we are tracking what's meaningful, not only for the state, for its accountability that needs to be there anytime and fiduciary responsibility for state funds, but the data and the outcomes data that's meaningful to the providers and ultimately to the clients that they're serving. That's really the balance that we need to strike.
Please. Mr. Chairman, thank you. And just to follow up on that, just to make it, to understand clearly. So if I wanted to know what the wait times in any one community with a community mental health provider, if there are wait times and what are they, do you track stuff like that?
Mr. Chairman, Speaker Summers, yes. Again, I want to be careful and mention that the community mental health centers, depending on their business and where they operate, have different business models that the Department of Health is not involved in, private pay or other contracts with other entities. But we do have reported, wait times for the centers, especially when it comes to residential. That's I think easy. Wait times for outpatient services varies by client and what type of service is needed. So we typically have historically looked at what's the time between first engagement and first appointment or first appointment and follow-up appointment. And that on its surface, I think makes a lot of sense. So you can gauge wait time. In practice and reality, it's not as effective as it sounds in some cases because there are many individuals, especially when we talk about these priority populations that I think the state is trying to serve better, that might have a first engagement and then disappear from the system. And we have a wait time metric there that's either inflated or deflated depending on what happens. So that's part of the work with our redesign and our behavioral health division and the providers that we're really trying to improve and strike a better balance on what data is actually actionable to the state, not only for accountability purposes, but for knowing two things. One, how are our clients doing? How are they faring with their outcomes? And two, what are those capacity issues that we need to make sure we identify and track regularly so that resource constraints can at the very least be communicated to the legislature, to others on what's needed going forward.
And it'll be, Mr. Chairman, thank you. And it'll be just a request. I would like to see how you report that and how I can view what we just talked about.
Mr. Chairman, happy to get with you offline and work on that.
Thank you, Mr. Chairman.
Cassie Crumpton.
Good morning.
Cassie, are you with us?
Yes, sir. Can you hear me?
Yes.
Good morning. I'd like to thank you and the other members of the task force for allowing me to be a part of this conversation today. I'm here as a private citizen, but I have a lot of history working in Wyoming across the behavioral health areas mentioned so far today. I have experience as an adult probation parole agent that had a specialized caseload of individuals in inpatient treatment programs. I worked in primary prevention and around alcohol, tobacco, and other drugs and suicide prevention. And currently I coordinate a treatment court program for Sublette County. I would really like to express my gratitude for all the conversations and care that's being put into the conversation today, because I think this is an excellent opportunity to improve upon what we're already doing well enough in the state. And it takes this multidisciplinary crossover from all these agencies to do so. I think my biggest area of emphasis today is I'd like to address some of the challenges that I've seen over the years. As a treatment court coordinator and Department of Corrections employee, is access to care for the individuals who are court mandated to receive services. Currently, our wait time at our local community health agency here in my county is about 3 months. That was just reported yesterday at a local prevention meeting. For individuals who have court mandates to get in to services or receive an evaluation in a restricted amount of time, sometimes that's a really big barrier for the lower level offenders. And it's something our local citizens are struggling with in a variety of ways. In my experience as a treatment court coordinator over the last 5 years, I've had 7 mental health care providers come and go on my team. My program tends to run about 18 months for an individual to successfully complete and graduate. And whenever they're having to restart with different providers, it becomes a big barrier to their success. And for many folks, it's just really difficult to trust the process and the system whenever they're having to restart like that. I do want to give my community mental health agency some credit because they try to do the best with what they can. But that amount of turnover makes my work in the diversion program really difficult sometimes. I don't know. I would love to be able to give you a formal report on why people are leaving at those rates, but I don't know that that's tracked in a way that's tangible or accessible. All I have is the ability to share what has been shared with me by providers that I had those working relationships with. To care for our clients who need these services, we have to care for the people providing the services as well. To become a licensed professional counselor in Wyoming, it takes about 5 years for the education and supervised hours to obtain the license to be an LPC. And once they get into the work, they're given really heavy caseloads that contributed to these long wait times. And they often have to work with poor reporting systems, sometimes unsupportive management or business-minded management, and they don't want to stay in an environment that inhibits them from providing the care that they did all this work to be able to provide to people in need. Those frustrations lead people from the community health agencies to provide services independently, but that also creates gaps in our ability to get people enrolled and successfully completed through those in our diversion programs as well. I don't know. I'm not a legislative minded person. Yeah, I'll leave that to the bigger brains in the room and people with more experience with that. But I do know if there were a way to collect information, perhaps through exit interviews of providers leaving these community mental health agencies, we'd get a better idea and understanding of what's really going on at local levels. I do also think that some of the things that tracking meaningful data would really give us a window to be able to improve our system in the efforts that are being implemented currently that have been spoken about today. Those expansion of services are really important. It would be nice to see collaborative areas of way to expand those services with private providers, whether that be through telehealth or potentially even creating avenues for smaller providers, not these huge mental health agencies, to be able to work with programs like mine or other diversion areas. that would be pretty cool and give us ways to meet the needs in areas like mine that don't have a whole lot of resources available to them. To close, I would just really again like to say that the state has done a lot with what we have currently and has been able to do that for a long time. So please don't think I'm knocking on it. I just really appreciate this opportunity to expand and improve currently what we have going on to save the lives of people in Wyoming and reduce that generational impact of substance use and mental health issues in families. And I'd be happy to answer any questions.
Questions? Albert?
Mr. Chairman, I don't have a question, but I want to thank Cassie just for getting on the line.
Cassie, I've got a couple of questions. I need some clarification if I can. And the reason I'm concerned is because where you're at in Sublette County is not uncommon for other small communities around the state that may not be in an area where the physical facilities for the community mental health providers are at, but you're being served via satellite or some other mechanism. And so making sure that those services through the contract through the community mental health providers to you is functional is important. And so then you made a comment that you said access to services and then in wait time of 3 months for the evaluation. And I'm seeing those as two different things. And so can you help me when we're having, if somebody needs an eval, Title 25, Title 7, is that what they're waiting the 3 months for? And that may clarify that. And then access to services, does that mean that the community mental health, that citizens in those small communities can't get in to see the community mental health provider, or they just don't have the services at the community mental health provider that you need?
Yes, sir. So I may need some support if I forget to cover anything because, I get on a one track and I get distracted. So I don't think that wait time and inability to receive evaluations is solely connected to those higher level needs like competency and things like that. I think I was more anticipating like an individual has a misdemeanor offense and they're court ordered to receive a substance use or evaluation or a mental health evaluation within 7 days to be compliant with their court orders. I don't think it's that higher level of need. We're seeing difficulties like, for example, a single mother being unable to receive an appointment for a substance use eval within the 7 days of the court orders because the single parent doesn't have $200 to pay for that evaluation. And so that puts them beyond that window. It's just small difficulties like that sometimes individuals don't have personal resources to access systematic resources. I've already forgotten the second half of your question. If you could refresh me, I'd love to address it.
Well, the second half of the question, Cassie, and well, let me first say that information was helpful. So we're looking at drug court evaluations, and that helps because that kind of even is a different spotted dog than the other two we were looking at. And so that's helpful. And you'll recall that we moved that over into the court system this year, and they've sworn up and down that they're going to do a much better job at that. And so my next question, the follow-up question is access to services. So how are you getting those in Sublette County? Is that satellite? And is it hard to get those services for people that, do you have services from a community mental health provider, or do they not serve that? Walk me through that, please.
We do currently have telehealth accessible through our community mental health agency, but to get to a point to where people can enroll in the program, sometimes that takes 3 months. I know our local community mental health agencies has partnered with providers through the telehealth systems for like medication management, for medication assisted treatment and various things like that, which has also been beneficial. we have access to things. It's just getting the right mix of services for the kind of care that individual needs and the ways that they can receive it. And that's going to be supportive tends to be difficult sometimes. And it's not across the board. It's just, it's hard to get people in where they need to be in the time they need to be without having some of those extensive waits for the lower level. This is more outpatient level services that I'm referring to, because we
Thank
don't
you.
have any inpatient facilities here.
Yeah, thank you. No, that's helpful. Just, we can't fix it if we don't understand it, so thank you. Any other questions for Cassie? Cassie, we need you to stay involved in this process as we move through. Well, and that's serious because you do represent an important constituency around the state, meaning the small towns that just have very few providers, and we don't want to miss the boat on how we're doing this, okay?
Yes, sir. I really appreciate that.
Katie, do we have anybody else online? Okay. With that said, I think we'll go ahead and break for lunch. Be back at 1. And we'll be ready to go.